Naledi, if you could just stay with us on these visuals, because any moment now you will have the other accused being brought up from the holding cells here. I'm going to ask you to stay with us for just a moment on that. I'm sure there is other news, but if you could just bear with us for a second as we wait for the other accused to also. The state has also arrived. I just hear some calls for them to call the presiding magistrate at this particular point.
Criselda, I don't know.
And if we could just talk a bit about, what the investigating officer had basically told this court.
Yeah, Criselda, I think if you're able to hear me in any way, I think just as we stay with those visuals, because we certainly would like to see the accused enter the courtroom there. But what we saw with the last court appearance of Nandipha Magudumana certainly was a lot of discussion around her appearance. I think one of the big questions that will come out as we're seeing Thabo Bester, even if he's appearing virtually, is going to be, is he not a convicted rapist and murderer? And should he be dressed the way that he is dressed? So let's talk firstly about appearance. That certainly has been a big talking point in this matter.
Naledi, at this particular point, I think best to comment on that would be the Department of Correctional Services. I guess would be best able to opine on that aspect of it, but we, as I indicated, have no clarity on when this application or when this talk had begun or discussions on the virtual appearance of Dr. Nandipha Magudumana and the processes that had been followed to ensure at this particular stage that the both of them then are able to appear virtually. But we then only heard this morning about the virtual appearance of Dr. Nandipha Magudumana. So both Thabo Bester and Dr. Nandipha Magudumana appearing virtually in this particular matter. But as you indicated, Naledi, correctly so, that the other accused in this matter would of course be arriving here at the court from the holding cells here. The presiding magistrate should be entering any minute now. And just to go back just a little bit, Naledi, I'm really going to ask you to bear with me at this particular stage as we try to wait for the court proceedings to get underway. You'd recall that accused number one, Sinohe Matsware, was a security supervisor at the Mangaung prison, and it's alleged that he took in the corpse that was placed in the cell of Thabo Bester on the 27th of April 2022. According to the investigating officer, Mr. Zolile Cornelius Sekeleni had hired a vehicle at OR Tambo. This vehicle was then taken from OR Tambo to Bloemfontein, and the same vehicle 2 days later, so recall on the 27th it had been allegedly hired by Mr. Sekeleni, and then on the 29th, this is of April 2022, that was the same vehicle allegedly used to transport this corpse onto the prison. I understand it had been at about 5 p.m. when the accused number one, Sinohe Matsware, had been reporting for work. And you'd ask yourself then where that corpse, how did it then land in the possession of Sinohe Matsware was accused number one. What we understand is that that corpse had come from the National Hospital, and then the corpse was allegedly claimed by Dr. Nandipha Magudumana. It's alleged that she was purporting it to be a certain Zanda Moyo's brother. She claimed she was assisting this Zanda Moyo to have that corpse buried. The magistrate, I understand, Desiree, please stay with us, is about to come in any minute now. Once he comes in, I will not then be allowed to speak in court. Once he does, we'll try to bring you these visuals live. Please stay with us. The magistrate is entering the courtroom. All right, all rise, and the court proceedings begin now. Stay with us live. The presiding magistrate about to begin now.
As the 16th day of May 2023, State Court Case number 28/113/2023, State against Thabo Bester. There should be 8 accused persons, but for now we have Mr. Thabo Bester, who is appearing via AVR. He is appearing from the Hosi Mampuru Correctional Facility, and Mr. Ishmael previously, Mr. Kapidi from Ishmael Attorneys was on record, but today Mr. Ishmael is appearing, and my understanding is that he needs to address the court regarding his involvement in the matter going forward. As it is.
First and foremost, where is Mr. Kapidi?
Your Worship, he's an associate at my office, so we both from RC Ishmael Attorneys. I'm here on behalf of the office.
Yes, what is the position, Mr. Ishmael?
Your Worship, the court will remember on the 14th of April, Mr. Kapedi from my office appeared. He came on record for Mr. Bester, accused number 5. On that day, I was not in court. I had already received instructions at that stage on behalf of accused number 2. I went to consult with accused number 2 that weekend, the Saturday, I believe it was the 15th. And then I foresaw there might be some issues. So I decided I'm not going to go and consult with Mr. Bester. Mr. Kapedi also didn't consult with him because there was an opportunity in court. We were supposed to go to Pretoria at a later stage. That Sunday when I spoke to Mr. Bester on the phone, I told him, look, I foresee issues that I'm representing accused number 2. I'm not going to come and consult anymore. He was aware that I already withdrew between him and I. And then today I'm just coming to court to officially withdraw. Since the 16th of April, he was already aware. He was already approached by another legal representative. He has a new legal team already. They will now come on record after me if the court will allow me to withdraw.
Let me establish with you. Today, an audio-visual recording has been arranged. Are you satisfied with the setup? Are you satisfied with everything?
Your Worship, well, as I said, I've already withdrawn between myself and Mr. Bester. I haven't been his legal representative for a while now. I'm only coming today to formally withdraw in court. That can be dealt with his new legal representatives. And they have, I do believe they do have instructions and they will address the court on that.
Mr. Bester,
yes, sir.
are you following the proceedings?
I can hear a bit faintly.
Didn't you hear the attorney, Mr. Ishmael, addressing the court? informs the court that he is withdrawing from record as attorney of record.
Okay. That is fine.
Thank you. Application by Mr. Ishmael to withdraw as an attorney of record is hereby granted.
Yes, please, the court, your worship, that's all my excuse.
Right, Mr. Bester. Okay, you are excused. Thank you. Mr. Bester, you have got the rights to legal representations. You may appoint an attorney at your own cost. If you can't afford to pay one, then you may approach Legal Aid South Africa to represent you free of charge. Or you may elect to proceed on your own in this matter. Do you understand?
Yes, I do.
What do you elect to do?
I have a legal team that is Mr. Pina and will take over my.
May you repeat yourself?
I have Advocate Pina and Lord that will be taking over my.
I do see before me, I do see Advocate Pina. Let me.
Yes.
Yes, let me engage him. Advocate.
God bless the Worship. Worship, confirm appearance on behalf of accused. I'm on the instruction of Chindo attorneys. The instructing attorney, Mr. Chindo, is here with me, Worship. Please, the court.
Thank you. Mr. Matuka.
Yes, as it is the purpose. Let me first indicate that the main matter will be dealt with in three phases. We are now dealing with Mr. Thabo Bester, and we will also be dealing with the matter of Ms. Nandipha Magudumana, also visual. Unfortunately, Court 19 in Bloemfontein is not connected to the Kroonstad correctional facilities, and therefore we will connect via MS Teams, and that will be in Court 28. From there, with the rest of the accused, we will then go back to Court 17, where we will be postponing Mr. Sekeleni, and thereafter we will then be proceeding with the bail application. Because in terms of the main case, there has been some engagement with all their representatives, including Advocate Pela, who is now on record, and there is an agreement that the main case be postponed to the 20th of June 2023 for further police investigations. I am also made to believe that Advocate Pela requested to address the court on a separate aspect just before we do the postponement. I will then pause to ask that Advocate Pela perhaps then addresses the court on whatever aspects he intends addressing the court. As a please.
God bless the Worship. Worship, just a brief background regarding the visual hearing. The prosecutor, Dr Masoko, called my instructing attorney last week Friday in the afternoon, requesting this matter to be visual, of which as the defense we have proposed to the visual hearing. One, it's inconveniencing for us. We need to take the instruction from the client, and as the setup it is now, Your Worship, we can't take instructions from the client. because as we are taking a particular legal issue with the client, everyone else will be listening. And throughout the proceedings, from time to time, there will be a need for the legal team to confirm something with the client. So we just want to bring it to the attention of the court that we never agreed with the visual hearing. And the prosecutor or any other person never came back to the instructing attorney to say whether the visual has been granted or not. We are also taken by surprise when we get to court today. We're expecting to meet with our client before we commence because there are a few issues that we wanted to iron them out with him. We're surprised to see that there is a visual hearing today of which he never agreed to. The issue that we want to converse to court, Your Worship, with the court's leave, we request to have our client transported here, being tomorrow or a day after. There is an issue that we want to bring to the attention of the court. However, it's important for our client to be here so that should there be any questions raised and the need to consult, we have that flexibility and opportunity to consult with the client. This morning we tried to talk to the client. It was very difficult through this visual setup. So, Your Worship, our request is that we don't have a problem with the postponement for further investigations. It is correct that the state did canvass the issue with us, that we don't have a problem. But our request is that it is an issue that we want to bring to the attention of the court with our client present physically in court. So with the court's leave, Your Worship, we request the matter to be rolled over to any other day, preferably tomorrow, so that we can deal with the matter that we want to bring to the attention of the court. Court, please, decision.
Before you take your seat, I have heard the public prosecutor addressing me that as for the main matter, he has discussed the matter with the defense and agreement was reached that matter be postponed until the 20th day of June for further investigations.
Court, this is, it is correct, Your Worship. That's the one that I was saying. For further investigations, for the matter to be remanded to 20 June, we don't have a problem for all the accused. However, we request our accused to be made available tomorrow. There is an issue that we would like to bring to the attention of the court with him being present in court, so that should we need to take further instructions from time to time, he's easily accessible. The visual is not working for us. I don't know about other legal representatives, but for us it's not working. Court, please.
Thank you. State.
It is indeed so that last week Friday, the court shall recall first that I placed it on record when we postponed the matter that DCS has requested that we consider the option of a visual postponement, which I placed on record. Subsequent to the court adjourning, I approached the attorney who was on record. That would be Mr. Kapidi. And that's where I got a confirmation that he will be withdrawn as attorney on record. He then alerted me to the fact that Mr. Ndou appears to have now instructions to represent Mr. Bester. And I indeed contacted Mr. Ndou after obtaining his contact from the said Mr. Kapidi as a courtesy call. Remember, he's not yet on record. He only comes on record today. But as a courtesy call, I made him aware that there is this issue of visual. Indeed, he told me that they are opposed to the visual postponement. I then indicated that, by the way, he's not yet on record. And I was just giving him a courtesy call. That's the first issue. It is not clear from Advocate Pila what application they intend to bring. I understand him to be saying they request that Mr. Bester appear in person tomorrow for an application that they intend to bring, and that it is difficult to consult with him by AVR. The court needs to separate the issues. Nothing stops them to consult with Mr. Bester. On their own, they need to go and consult with him wherever he is. It is not for the state to transport Mr. Bester so that they are able to consult. They can consult with him at any time with the necessary arrangements with the correctional services, and that's it. It would appear that they expect the state now to facilitate that consultation that he intends having, and to then transport Mr. Bester for his appearance. Joseph, Section 159 capital A of the Criminal Procedure Act makes provision for the AVR unless the court orders that it is in the interest of justice that the accused appears, which I do not know, which I do not hear so far, in terms of what is that they intend bringing before the application, bringing before this court. Safe to say they request that the matter be about over until tomorrow, so that Mr. Bester appears. Only then will they bring the application. But the court is unable to make an informed decision unless we are provided with details of this application and the like. That is my view, Worship. I don't see why Mr. Bester needs to appear for tomorrow. We are agreeable that the matter still requires some further investigation, and the state is bringing an application for the postponement of the matter for further investigation. Whatever application they intend bringing, let us be enlightened about it. As it is,
Court pleases, Your Worship. Bishop, I think the state missed the boat altogether. They misunderstood us. We don't request our client to be transported to court for consultation. No. It is the right of the client to appear in court in terms of the Constitution of the Republic of South Africa under the fair trial. Fair trial, amongst others, includes the accused being at court, being able to easily consult with the legal representation and so on. We have been to Kgosimampuru more often than not. We have consulted with the client. We don't need state to bring our client here for consultation. That's not what we are saying. The issue that will be bringing to the court as a preliminary issue requires our client to be here, so that should the court, honorable court, ask us any question, we are able to quickly confirm with him and consult with him. And it will make the work of this honorable court very easy. Your Worship, I don't know if you will allow me to give a glimpse of the preliminary issue that we want to raise with the court.
Yes, because I am in darkness.
Court pleases, Your Worship. Let me bring the glimpse. This honorable court will remember when Dr. Nandipha Magudumana appeared for the second time. This honorable court instructed Dr. Magudumana to remove the mask and the head so that the court can satisfy itself that the accused before the court, it is indeed the correct person. Your Worship, the preliminary issue that we are going to raise is that by the same token, we request this Honorable Court also to confirm and satisfy itself that the accused before court is the correct accused. It is against this background that we bring this preliminary issue. The warrant of arrest was issued, J50, for the arrest of Thabo Bester. A gentleman was brought to court and the warrant was cancelled by this Honorable Court to say this is Thabo Bester's warrant of arrest. We want the court to satisfy itself, Your Worship. Apart from J50, that warrant of arrest, nothing was finished to the court in terms of documentation, confirming that the accused before you is Thabo Bester. Your Worship, there is a purported death certificate of Thabo Bester that will also request it to be confirmed so that the court can satisfy itself. This purported death certificate is dated 3 May 2022, and it has got a stamp that is purported to be the Home Affairs stamp. So if we say there was a Thabo Bester in cell 35 at G4S, and after the fire and someone died, there is a death certificate, purported death certificate. I'm saying purported until such time that it has been confirmed, if this is true, by Home Affairs. And at a later stage, there is a warrant J50 issued for the arrest of Thabo Bester. And someone is brought before you, Your Worship. Remember now somebody escaped, there is a death certificate of that particular person, the purported death certificate. There is a J50 issued by the Honorable Court, and all of a sudden there is a gentleman that is brought. Our request is that, can the court satisfy itself that this J50 that I've cancelled, there is a documentation supporting that it is indeed this person that is before me, Thabo Bester. That's the issue that we'd like to take with the court as a preliminary issue before we come to the postponement. Can the state at least satisfy the court with any form of documentation that the person before you is Thabo Bester? That's our request, Joshua.
Mr. Dilla, this court has got no reason to believe that a wrong person was brought before court. The basis for that is that at first appearance, Mr. Thabo Bester was legally represented, and issue of identification was never raised at first appearance. So based on that, I've got no reason to believe that a wrong person was brought, because if a wrong person associated with the name of Thabo Bester was brought before me, that issue should have been canvassed there and there. But it did not happen. So why should a court have reasonable belief that a wrong person was brought forth?
Court pleases, Your Worship. Your Worship, this Honorable Court will recall the issue of confirming the identity of Dr. Magudumana was never done on the first instance. It was done when she was appearing for the second time, where the court wanted to satisfy itself that the accused before the court is indeed Dr. Magudumana. But it was never done on the first time. She was wearing her hat and her mask, with due respect also. It was only done on the second time. Same applies to our client. First appearance, it was never entertained. We are saying to this Honorable Court with due respect, can the court satisfy itself, like it satisfied itself with the issue of Dr. Magudumana? And Your Worship, we can't even take the responsibility why the previous legal representative did not take up the matter. Us, as the incoming legal representatives, we have been instructed to address the court on this issue. But if the court is satisfied without having received any form of documentation that confirms that the person before the court is indeed Thabo Bester, then we don't have a problem. We just wanted the court to be satisfied Because the only thing that is in possession of the court, like previous appearance, Your Worship, it was only the J50 with the name of Thabo Bester, nothing else.
But Mr. Pila, your comparison as to the lady who appeared before me, for the lack of a better word, it's misplaced. Because the person hid herself. It was as good as that person was not there. That was the reason for the confirmation of her identification. Mr. Bester appeared without having hid himself. So you can't compare the two.
Court, please, Your Worship. Your Worship, we are in the court's hands, but our issue was that can the court satisfy itself that the person before the court is indeed Mr. Thabo Bester? But if the court it's satisfied, we are indebted to the court.
Yes, what is your response? The public prosecutor further addressed the court to see when you made an objection through the instructing attorney, you were not off record. And you could not have agreed as to whether visual, or rather audio-visual recording be proceeded with or not. What is your reaction?
Court places, that is correct, Your Worship. The courtesy call that the state gave the instructing attorney warranted the response. It was not just a courtesy call to say, I'm calling you to inform you that there will be a visual. The state went to the extent of canvassing the response from the legal team. As much as we are not on record, I agree with the court 100%. However, we had to give the response whether we'll be comfortable with the AVR or not. And the instructing attorney's response was that, no, will not be comfortable. Now that we are on record, Your Worship, that's the first issue that I dealt with. To say the AVR is not working for us, I don't know about other legal practitioners. So moving forward, we'll request our client to be physically present in court. Court, please, discussion.
Yeah, I will.
Yes, if I may be allowed.
Yes.
Advocate Taylor is unfortunately dealing with evidence or a piece of evidence which is the subject of the charges against the very same Thabo Bester. The death certificate, which he says is purported to be a death certificate also. It is precisely the reason why we are here today dealing with this kind of cases, because someone is alleged to have died in the fire, which the state is saying it was not. And therefore it is the subject of the charges that are there against it. It has got nothing to do with the court satisfying itself with the identity of Thabo Bester. There's a person there in the accused dock who happens to be Thabo Bester, who is the accused. And I see no reason why for that purpose the state needs to transport Mr. Thabo Bester to come and appear here tomorrow. In fact, Advocate Taylor has already dealt with that issue, what the issue is about. And I concur and agree with the court that he cannot make comparison with the situation of Ms. Nandipha. It's two different issues altogether. And the issues that they want to raise are issues that should, in my view, be reserved for trial when we deal with the trial. As and when we deal with the trial. As it is.
Thank you. Ruling. As for the application moved by Advocate Taylor, I am less persuaded for the lack of merits. Application is dismissed.
As it is the court receipt on that basis, I request that the matter against Mr. Thabo Bester be postponed to the 20th of June for further police investigation. That he remains in custody as it is.
But President, the 20th is suitable for the defense.
Thank you. Mr. Bester, your case is
Yes, sir.
your case is remanded until the 20th day of June 2023. Court number 20A for further investigations.
Will it be virtual?
You will remain in custody until then.
Will I come to court or will on?
As to whether it will be virtual or you will come to court, that will be canvassed in due course between the state and the defense. Thank you.
As it is, may we then adjourn for now and move to court 28. I will give an indication in terms of the readiness for us to proceed as it is.
Thank you. Court adjourns.
Right, the matter postponed to the 20th of June involving Thabo Bester. Perhaps if at this stage I'm able to speak to Advocate Pilar. Advocate Pilar, good morning. is in Pretoria. You'd recall the state had indicated on Friday last week that an application had been brought for him to appear virtually. Reasons, of course, that had been cited much earlier on in this particular matter was that there had been some security concerns regarding the appearance of Bester or him being brought to this particular facility. Security concerns are raised pertaining to that. And what we heard now from his defense, lawyers that were placed officially on record for Thabo Bester, saying that they never agreed to the virtual appearance of their client because they would want to consult every now and again with their client inside the dock. They say it was quite difficult for them to do so when they communicated with him this morning. But now we proceed, of course, that matter relating to Thabo Bester has been postponed for further investigations to the 20th of June. We are now in this particular court where Dr Nandipha Magudumana now will be appearing before this particular court. No particular reasons, I guess, that had been cited. I'm afraid, if I had to head towards her lawyer at this particular stage, you might have, perhaps, let me just bring you in, Ndade. Why is Dr. Nandipha Magudumana appearing virtually? What are the reasons that have been stated? We understand with Mr. Thabo Bester, it had been said that there's some kind of security risk. What do we know? Why is she appearing virtually?
I think the state has already alluded to that point in terms of Section 157, capital A. So really there's nothing untoward, but we are in court and...
Perhaps you could tell us those reasons.
Section 157, capital A, is an empowering section to deal with proceedings in this manner. Yes, so hence I'm saying there's nothing untoward in respect of how these proceedings are really, taking place now.
Right. And with regard, of course, to that, of course, the lawyer representing Dr. Nandipha Magudumana, Mosheni Mutloung. In the next few moments, we're expecting, of course, proceedings relating to Dr. Nandipha Magudumana to get underway. Just to give you some details, just before court starts, is that what we've heard so far, you'd recall, with regard to Dr. Nandipha Magudumana, the investigating officer that had taken the stand last week, telling this court that it was Dr. Nandipha Magudumana who had claimed that corpse. Recall the corpse that is alleged, the first accused in this matter, Sinohe Matsware, had allegedly driven into the correctional facility. That a corpse was allegedly claimed by Dr. Nandipha Magudumana. Of course, this is contained in what the investigating officer told this court, that Dr. Nandipha Magudumana had claimed the corpse. She had claimed it to be Zander Moyo's brother and claimed she was assisting this Zander Moyo to have that corpse buried. That body was then taken to the Tusano mortuary, and that mortuary was supposed to bury that corpse. Then it's believed, according to the statement, of course, that was all right, court proceedings getting underway this second. We will just keep it quiet for now. Stay with us here on the program for the live proceedings of the bail application, of rather not the bail application, but we'll hear how proceedings unfold.
Thank you, Sir. State Class 28, World 113, World 2023, State against Ms. Nandipha Magudumana. Basically, we are now in Class 28 and we are conducting the proceedings via MSTs. Mr. Machini Mutloung is appearing for Ms. Nandipha Magudumana, who is on record, Your Worship, in terms of the charge sheet, is accused number 4. Your Worship, the state requests that as per the proceedings of the previous accused, that the matter against this accused be also postponed until the 20th of June 2023 for further police investigations, but she remains in custody. The date was arranged with Master Machine. That's quite please.
As it please the court, Your Worship, I confirm that I appear on behalf of accused person. Furthermore, confirm that the date of the 20th of June 2023 for further investigations has indeed been arranged with me. Your Worship, you would recall that in terms of the record, that the accused has reserved his right to proceed with his bail application. That is still the position. Notwithstanding the arranged date, we had a discussion with the state that in the event of any possibility arising, we may approach the state accordingly. But for now, Your Worship, the date of the 20th of June 2023 for further investigation is suitable as a court pleases.
Thank you. Mrs. Magudumana, are you following? Do you hear the proceedings?
I couldn't hear properly, but I think if I follow, I'll be able to hear, because I wasn't even sure speaking previously, and which lawyer was it my lawyer or another accused lawyer? So I'd like to just understand what's happening right now.
Yeah, in short, the first person who spoke was the public prosecutor, who made an application that the case be postponed to the date of the 20th day of June 2023 for further investigations. Then the second person who spoke was Mr. Mutoung, your legal representative, who agreed as to the date of the postponement, which is the 20th day of June 2023 for further investigations. Do you understand?
I understand your question.
Thank you. Your case is accordingly remanded until the 20th day of June 2023 in court number 20A for further investigations. You will remain in custody until then. You have reserved your right to bail application, and that right is kept in abeyance as was previously requested. Thank you.
As a court pleases, Your Worship.
As a court pleases, we may then adjourn and move to court. Appearance of other accused.
They're
coming down to the court now.
Right, the case against Dr Nandipha Magudumana has been postponed to the 20th of June. This is the very same day that Thabo Bester's case has been postponed to. And I'm just going to try and bring in Machini Mutawong at this particular stage. And Tate Mutawong, do you think you'll be ready by the 20th of June?
Very nice. Machine can't seems to be very
ona monkela dinotes o ntse ke ntse motho mo ka di enta ya ntse ka dinotes ke mo makaletse motho o ngola ka pili jwa
one thing. We are now in court 17, but sitting as 20A, state courts 20A stroke 113 stroke 2023, Sinoa Ishmael Matswara, Zolile Cornelius Sekeleni, James Dipolo, Mutinyani John Masukela, Diego France Makota, and Natasha Johnson. Before you is accused 1, 2, 3, 6, 7, and 8. We already dealt with the case relating to others. Your Worship, the state will similarly ask that the matter against the accused before court be postponed until the 20th of June 2023. The date has been arranged and agreed upon with all the legal representatives present here today. Accused number 2, Mr. Sekeleni, is out on bail. The state requests that the bail be extended on the same conditions. The rest of the accused will then remain so that we proceed with the bail application. As a please,
Mr. Moro.
As the court pleases, Your Worship, I confirm my appearance on behalf of accused number 1 and accused number 7. And I do confirm that the date of the 20th of June is suitable with us, Your Worship. As the court pleases.
Mr. Diva.
Please, the Honorable Court, I confirm my appearance on behalf of accused number 2. And I also confirm that the date is suitable, the 20th of June, 2023. As the court pleases.
Thank you, Mr. McNeil.
Thank you, Your Worship. Your Worship, I appear on behalf of accused number 3 in this matter. I confirm that the date has been duly arranged with me. Thank you.
Please, the court, Your Worship, I confirm that I appear on behalf of accused number 6. And I secondly confirm further that we have agreed with the state that the date of the 6th, the said date has been 20th of June has been agreed upon. Court pleases.
As it please the court, Your Worship, I confirm my appearance on behalf of accused number 8, Your Worship, and Mr. Gary Botha from Gary Botha attorney schemally. I confirm the date of 20 June 2023, Your Worship, as it please the court.
Thank you. Right. As for now, accused number 2, Mr. Sekeleni, your case is remanded until the 20th day of June 2023 for further investigations. You are on bail. You are warned to come back to this court at 8:30 in the morning and to remain in attendance. Failure to appear, warrant of arrest will be issued. Your bail will be provisionally cancelled. Bail money be provisionally forfeited to the state. The previous conditions as to your release on bail still remains. You were ordered to report yourself once a week at any time between 8 o'clock and 4 o'clock in the afternoon at Port Edward Police Station. You may not leave the magisterial district of Port Edward without having reported yourself to Colonel Flyman. You may not directly or indirectly contact the state witnesses. Do you understand?
I understand, Your Worship.
Thank you. You may stand down.
That completes my plans before this honorable court, Your Worship. May I please then be excused.
Excuse that. Thank you, sir. Yeah, for record purposes, appearances are same as before. The Colonel Flyman was still under oath. Colonel Flyman, you are still bound by the oath that you previously took. I just want to confirm with you. Do you confirm that the evidence that you will further elicit before this court will be the truth, nothing but the truth? If so, raise up your right hand and say, "Help me, God." Thank you. When this matter was adjourned, the state had already closed evidence in chief. Mr. Morori, I'm not sure whether you are ready to proceed.
Mr. Court, pleases Your Worship. I am indeed in a position to proceed. Your Worship, perhaps once more for housekeeping purposes, I seem to believe that the cameras may be rolling. See, one is pointed at me and another one is pointed at the accused doc. If perhaps I could just ascertain as to the position, Your Worship, in as far as that is concerned.
Yes, Mr. Morori, thank you for bringing that to court's attention. Since the matter was adjourned, there were new developments. I must state that after the limitations were made to the media house, the representations were made to this court as to permit the media house to proceed to broadcast the proceedings live. And attention was brought to this court that this court, it might have extended its power beyond its limit, in the sense that this court did not afford the affected party or parties, in this regard the media house, a space to react or to air out their views, as one would know that at all times the principle of natural justice ought to be observed. In other words, this court was myopic in exercising properly or observing the principle of natural justice, specifically the audi alteram partem on the part of the media. And what may seem to have been the order of the court might have arrived invalidly so, in the sense that the court might have acted ultra vires. And I am specifically taking piece by piece from the representation that were made to this court. And if the court could have acted ultra vires, in other words, if the court had made invalid order, that order would not be binding. I'm not sure whether you are following.
Your Worship, I accept what the court is telling me. However, Your Worship, I beg to respectfully differ with the court. This Honorable Court made an order. And that order, unless rescinded or set aside, still stands. It is a binding order. If it is that the court may have granted, it is so that the court may or may not have granted it erroneously. But that is not for this court to decide. If this court now says it is recalling its own order, it cannot do that, with the greatest of respect, Your Worship. The court is factus officio in as far as this aspect is concerned. It made a pronouncement, and that pronouncement was to the effect that I give the following order, and that order carried, Your Worship. And those would be my submissions, Your Worship. Unless the court is saying it is reviewing and setting aside its own order on account of its invalidity, and which we know the court cannot do.
Yes, let's check. The affected party was not given an opportunity to respond, correct? Is that correct, Mr. Mururi? The
Yes,
affected
yes,
party being the media.
Yes, Your Worship.
Right. And will you agree with this court that this court might have been myopic so far as the principle of natural justice is concerned?
Yes, Your Worship.
Specifically observing the Audi alteram partem rule.
That is so, Your Worship.
And court having arrived into the conclusion and made that order on the basis that the court did not observe the principle of natural justice, that order might have been invalidly arrived at.
That is so, Your Worship.
And then if the order is invalid, will you then agree with me when I say the order that is invalid from the court cannot be binding on the basis of it being invalid inception?
Your Worship, I respectfully wish to and beg to differ with this Honorable Court. And the words used by the court are correct. It says it might have been arrived at invalidly. So the avenue used may be incorrect. But the fact that an incorrect avenue used arrived at a certain order does not invalidate the order. An order of a court stands until it is set aside by a superior court. As things stand, this court gave an order. And if it goes on review, this court can say, I accept that I may or may not have erred. And that is a different discussion for another day. But as things stand, the court granted an order. All court orders are binding until set aside, Your Worship. The court cannot say, I think I made a mistake, and I therefore recall my own order. That would be incorrect, Your Worship. That would be a serious transgression on the rules that we have of this court, Your Worship.
Yes, in the same breath, would I also be correct to say, having not observed the principle of natural justice properly, and then having not afforded the media house an opportunity to respond or to react, I might have acted ultra vires so far as the order is concerned?
That is indeed so. Those are grounds for a review, Your Worship. And that is not an entitlement for the court to recall its own order. Beautiful grounds for a review, and should that come to that, then that can be canvassed at the right platform. As things stand, this is not a review. The court has made an order. We accept. To err is human. And if the court says, I may have erred, and I think I erred, that is correct. There's nothing wrong with that. But it is not for this court to recall its own order and then say, I think I erred, therefore I'm recalling my own order. It would make a serious problem. It would cause a serious problem. Because the rules are there for a reason. To say once you have pronounced on something, you cannot go back again and pronounce on the same aspect.
I understand.
And the pronouncement has been made here.
I understand that, Mr. Mururi. Let me ask you the last question. Can invalid orders be binding?
Indeed so, Your Worship. Until set aside, invalid orders are binding.
Okay.
Those are binding, Your Worship. Whether they were granted validly or invalidly, once there's a court order, it must be complied with to the T until it is set aside. And that is where we are, Your Worship.
Thank you.
As the court pleases.
Thank you. Mr. Makamedi?
Thank you, Your Worship. I fully agree with what my learned colleague is saying before this court. Your Worship, the order that was given by the court, whether invalid or erroneously given, it's still binding. There was an order that is final. It's not interim. There was no rule needs to say that we'll come back on this issue at a later stage to come and discuss that. So it is validly binding, and the only option available for this court is to have that order reviewed.
May it please the court, I concur with my learned colleagues, and I do not want to add further on what has been said so eloquently. And I rest.
Yes, please the court, Your Worship. I will abide by the decision of the Honourable Court, Your Worship. Yes, please the court.
Right, state, let me listen to the state. The views, if any.
I understand the court to be saying that the media house was not afforded an opportunity to air their views. But the fact of the matter is, initially they brought an application so that their views was not canvassed. In my view, I want to submit that they were actually canvassed, because they are the ones who initiated that. They brought an application, and based on their application, the legal team, we all converged and had a kind of a meeting, and based on our views, then there was this order. So all the parties' submissions were taken into consideration when the order is made. I want to submit that is the position. It cannot be correct that they were not given an opportunity, because they brought an application of which was granted, and having granted that application, the parties then subsequently made their submissions, and based on those submissions, that order was then made, specifically paragraph 1.3 of the addendum. So all parties' views were taken into consideration. And other than that, I will also abide by the decision of this court, insofar as that is concerned. As it pleases.
Thank you. My ruling on this matter, and I will align myself with the decision of Master of High Court, Northern Gauteng High Court, Pretoria versus Motala, Nomino Ofokio and others, 2011, whereby the principle that was tabulated there is being used by this court today, that invalid orders are necessarily not binding until they are being taken to appeal. Having said that, I do order that the amendment as per the guidelines that was initially issued be put into effect, in that media house is allowed to broadcast live these proceedings. And I must further indicate that it will also be in the interest of justice for court to arrive into this decision. The issue of broadcast by media live, it is a collateral issue, by the way. The main issue here, it is the bail application of the accused before me. And when this application was made for the purposes of limitation, there is no any form of prejudice that was indicated to me that should the proceedings be broadcast live, then there might be any prejudice to any of the party to the proceedings. And to keep this matter in abeyance or to adjourn this matter for the purpose to consider otherwise, it will further delay these bail proceedings. It is in the interest of justice that we proceed with the bail application in this form. Thank you.
As the court pleases. Your Worship, may I turn my back on the court to take an instruction?
Yes.
Yes, sir. Just before you take instructions, can there be some limitations placed on that?
Thank you, Mr.
In the form of my request would be, as much as the audio of witnesses may be live, I don't mind, but then the face and the identity of the witness that is now giving evidence strictly be prohibited. That will be my submission, Your Worship.
Okay.
That's a business.
Perhaps to bring into the records the amendment as brought forth by this court. This will read thus. Everybody will remember that this court read out clause 1.3 previously as per the guidelines. And as per this amendment, you will indicate the following. This to your clients with regard to the contents of clause 1.3 of the addendum as informed by the guidelines that were set. As is currently happening, SABC fits into other media houses. For this purpose, 1 or 2 static cameras will be allowed for the live recording of the proceedings. That simply means to indicate real time. All the bail proceedings will be thus as recorded. In the event that a concern be raised with regard to the revelation of the identity by the state of any witness, it shall be abided by. Should there be disagreement or objections, then the presiding officer will make a ruling. No interview of any of the accused persons should be conducted in court. No roving cameras and disruptive movements by media personnel in the courtroom. No taking of photographs will be allowed during the court proceedings. Other unforeseen issues around the media on the part of the legal team and or the state that may come up during any stage of the proceedings will be raised and decided there and there by the presiding officer. All the other issues in the addendum relating to the decorum of the court still stands and should be adhered to. I want to believe that is clear. And Mr. Matoko, that also covers your concerns. Thank you, Mr.
Court pleases, Your Worship. May I turn my back on this court to take an instruction?
Yes, you may.
the court pleases, Your Worship. Your Worship, I'm indebted to this honorable court for the indulgence. I am in a position to proceed, Your Worship.
Thank you. Are you ready, Lieutenant Colonel Flyman?
Yes.
Thank you. Mr. Murori, with the permission of the court, you may kickstart with your cross-examination.
Yes, the court pleases. Colonel, good afternoon. Colonel, before we start, it would be inappropriate of me if I did not commend you on your 28 years of selfless service to this country. And I think I speak for most of us when I say we are indebted to you.
And Kiahola had to go as well as City Gilla, Lebasibiti Mo Bana Bakabana Hore, Rai Lebuela, Sibitoya, 8 Mazo. I thank you.
Colonel, being an officer of 28 years in the South African Police Service, am I correct to accept that you understand that the purposes of this bail hearing is not to determine the guilt or otherwise of any of the accused persons, applicants before this court?
Colonel Joloka, when I was we people about 28 years, or less bonusing. Ketanka hore wa utlwisisa hore sepheo sa bail ena kapa kopo ena ya bail ha se o bontsha tsa hore na mang o molato mang ha molato le eng ditho tse jwalo ke bontsha fela ke o tseba sepheo sa bail ke I understand that.
And in your own words, what would you say is the purpose of bail proceedings?
I got to blame the how. What are king sepheo sa hore ho be le ntho e o thweng ke bail kapa ho be le tshebetso e tje kopo e tjena ya bail?
Ke o etsa surety ya hore moqosuwa wa tender court o worship.
Well, the bail application would be to make sure that an accused person does attend court.
And you testified, Colonel, in exam-in-chief that your investigations are not complete. Is that correct?
When I know about Gimba, how I know Blela Mona, we say the people are so fail. That's correct.
And you further indicated that it would take you another 2 months or so to finalize the investigations.
And when I know Akanyetsa fail, or Lekanyetsa, we think China can guard the Hoditsepe or Tatel. Yes, I said it could take me from a month to 2 months to complete the investigations.
Furthermore, you also...
Yeah, Mr. Mururi, don't fly. I must also take notes.
Must apologize.
Thank you.
I must apologize. I'll slow it down. As the court pleases.
Yes, thank you.
You also indicated, Colonel, that you envisage that there will be more arrests in this matter.
And when I will say, on a leponelo pay, or a Santa Nonale, but Babang happy banse but for Swara, Casey. Correct?
Would you agree with me, Colonel, that your investigations going forward may have a bearing on even the charges that are before this court?
Jale, when now Otadimilana Lena Hakire, the Pupuzota, Hanse, the Apele, the Kana, the Ama, Lady Kosu, Zena, but one about Kosuan Katso. That's correct.
That in fact, already you did a preliminary investigation. And with that investigation, it revealed that the prosecution may proceed and prefer a charge of murder against accused number 1 in particular.
And when we say happy, when I did Puputsanyana, just had so sense audience. And the Puputun say, when I Ufumane Hore, Mochuchi, Sikapa, Buchuchisi, Bokana, Bakenya, Leko Soyapola or Hasanong. Le Mukusho Ape.
But that was never said.
Mr. Court, please, Your Worship, I don't believe my question was kept up correctly. I said, in the preliminary stage of your investigation, I put it to you. In the preliminary stage of your investigation, I did not say he testified to that effect. Perhaps I'm calling upon it. I can rephrase, Your Worship. It's not.
Yes, but even then, there is no charge of murder currently.
Your Worship, it is common cause. It is common cause, and my colleague withdrew the charge in court, placed it on record that there was a charge of murder, and he withdrew it. And that is what I'm getting at, Your Worship. I don't know what prejudice there could be. Fact of the matter is, there was a charge of murder preferred against accused number 1. Subsequent investigations ensued, and that charge was withdrawn. It was withdrawn in court when we started with the bail application. I do not know what the state is coming to.
Yes, what the public prosecutor is trying to establish is to the relevancy of the anticipated charge being put back. That is one of murder against accused number 1.
No, Your Worship. That is not what we are saying. In fact, the relevancy here comes to the fact that there's outstanding investigations, and initially, there were preliminary investigations. Those investigations led to the state preferring a charge of murder against accused number 1. That is a fact. Further investigations ensued, and those investigations, those further investigations that then ensued, led to the state withdrawing a charge of murder. And that is a fact, Your Worship.
Okay, perhaps just to rephrase the way you have put your question to, or your statement to the witness.
As the court pleases.
Thank you.
Colonel, in this matter, you have made certain investigations. Is that correct?
Sir, Colonel, casing ena ho na le diphuputso tse itseng tso di entse. That's correct.
And in those preliminary investigations, you agree that the accused persons, and in particular I'm talking about accused number 1 now, were charged with certain charges that were preferred at that time. Is that correct?
And the diphuputso tseo tsa sethatong tseo e neng diphuputso tsa pele itse ka morao re di etsuwe yaba bakusuwa ba qoso ka diqoso tse itseng haholoholo ke buella mokusuweng wa pele o na qosuwa le ka meda wana mo. That is so.
Subsequent to accused number 1 being arrested and charged with, amongst others, murder, you did further investigations. Is that correct?
And I come around here, accused number 1 as far and ele hore dikosong tseo a tshwarelang tsona la kapa tsa shebaneng le tsona ho na le ya polao hara tsona ho ile ba le diphuputso tse ding hape tso di etsang. That's correct.
And it is in these subsequent investigations that you realize that the murder charge will not be sustainable as at this time.
Ke diphuputso tseo he tse tlileng ka morao mo o ile wa bona hore koso ya polao yona ha ena khona ho ema.
Is that statement correct, Mr. Moruri? Is it him who decides on what charge to be preferred?
Your Worship, I can rephrase that question.
Thank you.
Mr. Court, please. In the subsequent investigations, Colonel, that you, I accept, would have presented, did you present the findings of your subsequent investigations to the state prosecutor?
Okay, kamera re wena o etse diphuputso tse ding o ile wa fana ka hore na wena o fumane eng mo diphuputsong tseo o fana ka sephetho sa hao ho motjhutjhisi. Yes, I did.
And is it thereafter that the prosecutor decided to withdraw the murder charge? Or in your opinion?
O ya ka mokgwa wena o nana ka teng ke wona ka mora sephetho seo sa hore o fana ka sona motjhutjhising a ileng a nka qeto ya hore yena koso ya polao ha sa tswella ka yona. That is correct.
So you will agree with me that your investigations, as they go on, in fact, as they have progressed, have also had a bearing on the charges that is preferred before against accused number 1 and 7.
Jalo dumelana le nna he a ke re diphuputso tsa ho ya ka mogodi tswelletseng ka teng di ile tsaba le ka mkhodi amang dikoso tse le hore mokushwa wa pele le wa bosupa ba shebane le tsona.
Ho jwalo, Your Worship.
I do.
Colonel,
before you proceed, I think the wording might be ambiguous. I'm not sure. When you say the continuity investigations do have bearing, what bearing?
Well, Your Worship,
negative bearings, positive bearings, what bearings? Because that word may connote something else.
Well,
what I'm trying to say is that your questioning or your statement must be clear, because the wording might be ambiguous in a particular way.
Perhaps to clear it out.
Yes.
And in this particular regard, your investigations, in short, your further investigations led to the state withdrawing what I am going to argue to this court was the most serious charge preferred against the accused number 1, which is the charge of murder.
Tsa bakela hore state ba khala case e ona ke tlontshanganyisana hore inele yona e leng hore ke yona empe ka fetisisa mo dikosong tse le hore batho bana ba shebane le tsona.
Ho jwalo.
That's correct.
Now, Colonel, you testified as to how accused number 1, and I wish to refer to him, Your Worship, with your leave as accused number 1, and where I refer to applicant number 4, I'll refer to him as accused number 7, perhaps just for it to make sense in my head. I apologize if the court so wishes for me to do so.
Without necessarily directing you as to how you elicit your evidence,
yes.
Wouldn't it be prudent perhaps to deal with applicant number 1?
Yes, Your Worship. No. I was just saying that I will deal with applicant number 1, and that is how I have it. And once done, I will then go to applicant number 4. But if I happen to use the words interchangeably, applicant number 1, I may refer to him as accused number 1 interchangeably if the court is satisfied with that.
Yes.
You testified, Colonel, that there are certain investigations that you conducted, and those investigations led you to linking accused number 1 in particular to certain actions within this alleged crimes.
So we tell now ile wa ba le phuputso tse di etsang e di phuputso tse di etsang di le etsa hore wena ho be le ka mogwa o wena o kenyang accused number 1 casing in a ka teng. That is correct.
And Colonel, without going into much detail, I can put it to you that accused number 1 will at the right forum come and dispute all that you have put against him.
Accused number 1 you ha ho setse a fuwe monyetla le ena hona le mo apakanteng o tlo di hana kaofela dintho tseo wena o reng o di entse tlolong ena ya molao.
Ke sentse ke ebe hore ke di bopaki bo ke faneng ka bona ke se wa sitse.
I still maintain that the evidence that I provided here is just what he did.
Colonel, you'll agree with me that the evidence that you provided here is not first-hand evidence. In fact, it is what you have learned from your will-be, or what the people who would be state witnesses when the matter proceeds.
Sheba ke na le bona bopaki bo wena o tlileng ka bona mona se bopaki bo eno hore bo tswa ho wena ka mokgo wena o bone dintho di etsala ka teng. Ke bopaki bo bonkileng di paking tseo ho ka etsalang di ke mona casing ena di tlo paka.
Ke bopaki bo ke bothotsi di witness moship.
Yes, it is indeed the evidence that I obtained from the potential witnesses.
And you will agree with me that those witnesses that you are mentioning now are not before this court.
Yes.
And in fact, for any determination to be made on their credibility by a court of law, they would have to come and testify.
And hore na ho shebuwe bona ba tshepaetse ho lo kae batho bao ho tlameha ba tle mona ba tlo paka.
Ho jwale ho sheba batho.
That is correct, they are indeed going to come.
Colonel, I want to take you through your testimony in as far as it links accused number 1.
Ona ke batla go tataise ho ya ka bopaki ba hao ka mokgo wena o reng bo kenyelletsa accused number 1 ka teng.
And I will also touch upon what I am instructed to be pitfalls in your investigations.
And hanze ke etsa jwalo ke tla nna ke nopola mo ho thweng wena o entse phoso teng diphuputsong tsa hao.
You testified that accused number 1 was a supervisor of the EST unit. Is that correct?
Wena bopaki ba hao itse accused number 1 e ne le supervisor mo uniting ya EST. Kenneth? That's correct.
And that the duty of the EST unit was to, I want to quote you verbatim, the court would indulge me. Keep a lookout on the offenders, amongst others.
Wena we tsebise betwa EST ne le hore ba shebe ba kate ba tshwaruwa hara mesebetsi e meng ya EST. That's correct.
And I'm instructed, and I put it to you, that the EST does not work with simply guarding offenders. It is merely there for emergency purposes.
And then trail go fire now or EST ha sebetse ho shebana le batshwaruwa. EST e mo bakeng sa maemo a tshwanyetso.
Do you have a comment on that?
Ra le tshwaelo ntwenye.
Ke tseba ba kata le batshwaruwa e boshika. The way ke fumane ka teng.
The way I found it through my investigations, they also guard the prisoners.
Colonel, you testified that accused number 1 was dismissed from his employment. Do you know when he was dismissed?
When I was we say accused number 1, we le alele ku mosebetsing wa hae wa tseba hore na ona le kwa meaning.
Worship sa fosi sa re ke di 29 tsa September 2022.
If I am not mistaken, I suppose it was on the 29th of September 2022.
And you also testified that the witnesses that testified, or rather some of the witnesses that testified in the disciplinary hearing, would also be testifying in this criminal trial. Is that correct?
We now bakile hape hore dipaki tse ileng tsa paka mo disciplinary hearing e tlo ba dipaki hape mona nyeweng ena ha isetswela. That is correct.
And you will agree with me that the disciplinary hearing took place at least over 6 months ago.
But na ke re disciplinary hearing eo e la etsala mo dikgweding tse 6 tse fetile. That's correct.
I did not hear you testify that any of these purported witnesses have indicated that accused number 1 threatened them or tried to influence them in any way.
Haka utlwa wena on sa bopaki mona bo reng accused number 1 o ile a leka ho tshosetsa baki feng kapa efeng ho ba ba sentseng ba pakile kapa a mo beya bophelo ba hae ka mosing ka mokgwa o feng kapa o feng. Yes, I did not testify to that effect.
And for completeness sake, is there such a witness who said they fear for their life that testified against him at this hearing?
Hore ntwe felle hona le paki e jwang e reng yona e tshoseditswe ha sale e pakile ko hearing eo jwale bophelo ba yona e ka go sebele kotsing. No, there is no witness. There is no witness who's claimed that.
But you testified that you have an apprehension of fear, or a fear that your witnesses may be interfered with, influenced or threatened.
When I still pagi onale Thabo ya hore dipaki tsena di kana tsa tshosetswa kapa tsa ka mo di tshosetswang ka teng kapa tsa hlohlua moya tsa tshusumetswa ka mokgwa o itseng. Yes, that's correct.
What brings this fear about?
King e fan Thabo yo.
Dipaki tsa mmuso hore di ka tshosetswa ke accused number 1.
I have a fear that the state witnesses might be threatened by accused number 1.
Put it to you, Colonel, that accused number 1 has already said under oath, that is evidence before this court, that he will not interfere with your witnesses.
Accused number 1 sa buile ntwe eo. A bolela le khotla hore yena ha hona ka mogwa ka a tshosetsang dipaki ka teng. Go ha hona ka mogwa yena a tlo itsunya ho dipaki ka teng.
Ka mehla di accused di tshwarwa le worship ho etsa le sona seno se ba itseng ba se worship.
In usual instances, the accused persons always confirm that they will not interfere with the witnesses, but to the contrary, it turns out they do.
Are you now testifying that your view is based on your experience and not your investigations, Kenneth?
Jwale o reng wena o ya ntwena ya o hlahisa mona e ya ka bo phitlhelo ba hao mosebetsing wa ha esa le ntwe e le hore e tswa diphuputsong tsa hao
ke tswa diphuputsong le worship ke ne ke hlalosa se advocate ana se a se bolela ho.
That is based on my investigations. I was only expatiating on what you were asking me.
Colonel, you have testified right now that no witness said they were threatened. What in your investigations says they will be threatened?
Sheba o ka da hore jwetsa ona jwale hore ha ona paki e feng kapa e feng e itseng yona e tshoseditswe. Jwale diphuputsong tseo tsa hao tso di entseng ke diphuputso di feng tseo bontshang hore di tla tshosetswe fa.
Ke ho bane information ene ki fumane ho thwe accused number 1 ke motho ya linti le digeng.
That is according to the information that I got. That informed me that accused number 1 has a link with the gangs.
And you did not find this prudent evidence to lead when the state prosecutor meticulously took you through your evidence?
Jalo bo fumana hore tlhahiso leseding eo ha e bohlokwa ka lo hore ka hlahisa ha motjhutjhisi ana ntse a o tataisa mo pakeng ba hao nakong e fetileng.
Ha ke ya ka botebo jalo ka ha motjhutjhisi ana itse hona ke hlahise fela linki e bontshang nkosuwa e lona.
I did not go in depth as the prosecutor had guided me, that I should only highlight how each accused person was linked to the crime.
Colonel, the final question from my learned colleague for the state to you was, do you have anything else to add? And you said no.
Ona potse o qetela he e leng ya botswa ke motjhutjhisi mo qetellang bopaki ba o teng ko re na ona le ntwe nngwe hape o batlang ho fitisa ho itsibisa aso botsing ka yona na wena o araba o re ai. That's correct.
Put it to you, what you are testifying now is nothing but an afterthought, Kenneth.
Togo jwetse ntwe o re bolelang yona hona jwale ke ntho o qetang ho inahana hona jwale.
Che ha o jwale.
No, that's not so.
Will you agree with me that the disciplinary hearing procedure impacted accused number 1's livelihood?
Wa dumelana nna ha ke re disciplinary hearing yana ila ba ya ba ka mokgo e bangle e amang boiphediso ba accused number 1. I do not know.
But you agree that if one is fired from their employment, they lose an income?
Fellow dumelana le a ke re motho ha le le ko mosebetsing ha sana le kene motho. Yes.
And for someone who, like accused number 1, has placed his personal circumstances before this court and indicated that he's a breadwinner, that would be a serious problem, would it not?
And jolo ka accused number 1 le nana sentse hlaisitse hore yena ke breadwinner mo a phelang teng. Ho lahlela hae ke mosebetsi o ka ba ka mathata ntate.
Ke dumela hore nka etsa pele nka etsa ntho empe e leng kgahlano le molao. Jolo ke dumela yena le motho ene tshantse o aware o feta batho ba. A ke ba ina hanne hore ke tswe ke etsa the implications tsa yona ke ditlamorao ho nna.
I believe when one is committing a crime or committing an offense that is against the law, like the accused has done, he would have considered the implications that would come thereafter, especially given the accused number 1 especially, how much more knowledgeable than other accused persons he is.
Colonel, please answer my question. And my question to you is, do you agree with me that someone who's a breadwinner losing an income, that would have a dire impact in their life? That was my question to you.
Okay, araba potso yena Kenneth e go butsitseng yona. Ke ne go butse fela hore na wa dumela hore motho a nang le letseno ha a lahlelwa ke mosebetsi, mo ho lahlela ho ha hae ke mosebetsi, ho tlo ba le ditlamorao tse mpe bophelong ba. That's correct.
And therefore, one would accept that such a person would have a reason to protect that interest with all they have. Is that not so?
Jole ka mo la motho a jwalo a tsebang re tlo mo bakela mathata ntweo a ka e tshireletsa ntweo ya lekeno le la hae ka ntwe mo le ngwana le nyona. How jwalo? Well, I do not know.
Put it to you that if accused number 1 had a reason or was a violent person, as you allege, you would have complaints that he has threatened somebody because he lost his livelihood. But he did not threaten anybody.
Sheba yena ntwe ke bolela nyona ke hore ha bene accused number 1 ene le motho ana le dikgoka e ka be ho setse ho na le ditletlebo bona jwale hore o santse a batlile ho di etsa dikgoka tsa hae kae kae hona le matshosetsi kae kae ene ntwe e jwalo ha iso ka etsa. I do not know.
Well, Colonel, with all due respect, you're not here to testify about what you know. You're here to testify about what your investigations have led you to believe at this current stage. Have your investigations indicated that? That's a yes or no question.
Sheba ya Kenel, wa mna ka hlomphe kgolo ha wa tla mona o tlo o ntsha bopaki ka ntho e tsebang. O tlile mona ka o tlo ntsha bopaki ka dintho tso di fumaneng diphuputsong tsa hao. Jwale diphuputso tsa hao di o file yona ntho ya hore motho na o di kgoka ke potso ya hao e kapa tjhe.
Ho jwalo.
That's correct.
Colonel, did you testified that you looked into the criminal record history of accused number 1?
When I say we history, I the record side, the criminal. Okay. That's correct.
Does he have any criminal record whatsoever?
Well, criminal record too. No, he has none.
Do you accept that the only indisputable proof that you could bring to this court that accused number 1 is a violent person is if you are showing that he has in the past engaged in violent activities?
So I don't know bopaki bono bo tla hlaela ka pele bo bontshang hore bo ka se phisiwe ke mang kapa mang hore accused number 1 ke motho a di khoka ke motho a violent nkabe ele bopaki bo fumaneng di criminal record tsa hae. I do not know.
I'll leave that for argument, Colonel. Now, further testified that there was money coming into accused number one's account. And this money was coming from a certain TK. Is that correct?
When I talking about it's only the charity in the account to accused number one. And the charity in the charity is 120 TK, can it? That's correct.
Was the only identifying feature of the payment or the payer, the initials TK? Was that all? Did it have a surname?
Siya ka mkhuwana no bona ka teng kapa o fumaneng ka teng motho eo entseng a patala o tswiki TK ona hlahella fela ka TK eo fela kapa ona le fane mo
ona hlaka TK
This individual was only identified with those initials TK.
But you testified that TK, you believe TK to be Thabo Bester because he sometimes has aliases. Is that correct?
When I say o khola hore TK ena ke Thabo Bester ba Thabo Bester ona le mabitsonyana a mang ha ba ipitsang ka ona. Correct?
I put it to you that TK can mean a variety of things.
Toko jwetse Colonel TK e ka bolela ntho tse ngata. Fair.
The first one, TK could simply be anyone whose name starts with a T and the second name is a K, initials. You accept that?
Ya pele, TK e kana ba motho e mong le mong fela a nang le lebitso le qalang ka T se name ya hae e le K. Wa dumelana le? I do not agree with you.
In fact, TK could also be a nickname.
And I bet TK can have a nickname if I do not know.
We will deal with this aspect at trial.
Well, the
you testified, Colonel, that accused number one was acquainted to the deceased in this matter.
Accused number one on a atwailane le mufu asa elam na case ngena. That's correct.
Some Harv's rules in terms of moving forward with this matter in terms of the lunch and the like, because I see now it's lunchtime unless we agree that we proceed throughout lunch. I just wanted us, just before he gets into details with this question, pardon me, that we make that determination.
Thank you for alerting us in terms of time.
That's the point. Your Worship, I do not wish to sound selfish, but I'm on my feet, Your Worship, and if my colleagues are with me, then we can proceed until such a time, perhaps, that one of my colleagues would indicate their discomfort. I'm in their hands, Your Worship, and of course, your more than capable hands, Your Worship.
Yes, let me hear from the individuals. Yes,
Your Worship, I don't have a problem if we proceed, maybe for an hour or so.
Certainly 1 hour more won't do any harm, Your Worship, if you please.
Yes, please, I concur. Let's proceed.
Okay. Does that tend to suggest that lunch is taken later or we proceed through with no lunch?
I believe, and I do not want to speak on behalf of any of my colleagues, but perhaps a 15-minute adjournment at 2 o'clock just for a break, comfort break, and we are back in court.
Okay.
I agree.
Okay.
Then
agreed. Yes. You may proceed.
Your Worship, you did not indicate your view, but I accept that you are with us.
Let's proceed.
Colonel, you testified in depth about where the deceased in particular was found. And I don't want to go into that much detail.
Bona ke le rona re boleletse ka botebo ya hore na mofu o ne a fungwana kae empa mothating ona ha ke batle ho kelella holoholo dintleng tseo tso so buile ka tsona.
Sorry, in particular, and I'm clearing it out, Your Worship.
Yes,
in particular, where he was found at the taxi rank and then taken to the hospital.
How long more no of money thing taxi ranking, Yava Unkua Wiswa Spata?
Okay, Mr. Mururi, sorry to interject. I did not do justice with the earlier request that was made.
Yes, Your Worship.
May I establish, please, with other court officials?
Oh, yes,
Thank
yes.
you.
And my apologies, Your Worship. I apologize to
you.
my colleagues.
And I also apologize for having let the matter be proceeded with. Mr. Manyosi, let me hear from you. Is it in order with you for matter to be proceeded with as suggested?
Yes, so she's saying that with the action is already in momentum and we don't want to break that. And we know the agency of this matter. Yes.
Yeah, we don't elaborate too much. Then thank you.
The court order may also bring one thing to my attention. Perhaps my learned friends can clear it up. That we should consider that 1 o'clock is also lunchtime, where the awaiting prisoners are also fed. So it should be established, if they don't have a problem, that they can be fed later.
Yes, Mr. Morori. Inclusive are your clients. Apparently, during a lunch period, they must have access to food, your clients. You may establish, perhaps with your clients, whether it is in order to proceed with them without having access to food.
May I turn my back on this?
Yes.
Maybe all course.
Yes, yes.
Your Worship, I am told to go full steam ahead. I have just established or ascertained from my learned colleague from SABC, indicated that they will reserve a meal for them, so we can proceed, Your Worship.
Thank you, for as long as it is agreed.
I think I speak for all my colleagues.
Yes, that's right. Yes, I've already got a confirmation from your colleague. You may proceed.
Now I seem to have lost my bearings, Your Worship. If the court would just indulge me for one second. Yes. Colonel, you indicated that the deceased was then taken to hospital, and that is where I'm going to leave it.
That's correct.
Do you have a post-mortem that indicates the cause of death of the deceased?
Well, post-mortem yes, I do.
Would you enlighten us?
Yeah, Mr. Mururi, I'm trying to think as to what relevancy will this be, because there is no charge of murder. I know there was a reference to the murder.
Yes, Your Worship.
But I'm not sure where are you stretching it.
Your Worship, if the court would indulge me, it will become very clear in the next two questions.
Okay.
Mr. Court, please.
Yeah, I got like saying that. Ka postmortem. Or na mufu or blaweke.
Postmortem report ne itse mufu hana hauna smoke inhalation kama tsafunga hai.
The postmortem report indicated that the deceased had no smoke inhalation in his lungs.
Happy unanale fracture.
It also indicated that he had a fracture on his head.
Did you establish the cause of the fracture?
We now ilewa fuputsa hore na keng e entseng hore motho a fracture hlo.
Honorable diputso santse di tswela pele o tla ba boima ho nna ho e hlalosa.
Well, the investigations are still underway, so it would be difficult for me to explicitly say.
Okay, I accept that. But you are investigating the cause of this fracture.
Empa wena o santsane o ifuputsa taba hore na ho tlile jwang hlooho ya motho e fracture. Yes.
Colonel, you testified that the deceased and accused number 1 would, just 1 second, drink together, I believe are the words that you used.
Wala on still paking ba ha hore accused number 1 le mofu nene ba ne ba ka ba nwe mo.
We are getting information e ke fumane go shi.
That was according to the information I obtained.
Put it to you that accused number 1 will come to the right platform and say he does not know the deceased in any way.
Tobo jetse ha a tla ena accused number 1 a tlo ipakela mona ha so tshwanelele a paki o tlo bua hore yena ha a tsebe mofu ho hang. Well, I do not know that.
What do you not know, Colonel? Do you not know if they knew each other, or do you not know what he will come and testify?
Ke o sa tsebe taba o sa tsebe ke hore ha ba ne ba sa ha o tsebe taba hore ba ne ba tsebana ka ba o tsebe taba hore o tlatla a tlo paka are.
Ha ke tsebe o tlatla a tlo paka are.
I do not know what is it that he is going to come and testify.
But you will agree with me that you personally do not know if accused number 1 and the deceased drank together. It is what you are informed of. Someone else once more.
Empa dumelana nne ya no hore wena ka boena ha o tsebe hore ba ne ba nwa mmo ke ntho fela o utlwileng batho. That is the information I got from other people.
Colonel, when you say, your information, did it say where they used to drink together?
Well, no.
Do you perhaps have a specific date on which they were seen drinking together?
It's a paming mo baneba bonwa banwa mo. No, I do not have a date.
So you do not have a place, nor do you have a date, but your information says they used to drink together.
Jalo wena ha ona date, ha ona le sebaka se bone ba no la teng, empa le sedi lo fumaneng ke hore batho ba bane ba nwa mo. That's correct.
Put it to you that accused number 1 has never drank with the deceased at any tavern, club, pub, or any other place of that nature.
Accused number 1 ha asoka anwa limufu. Taverneng e feng kapa e feng, clubeng e feng kapa e feng, kapa kae mo ho nwang jwala teng. I dispute that. According to the information I have, they were drinking together at the taverns.
Colonel, we have already established on your own evidence that this information you have does not have a date or a time. So I will reserve that for argument.
Well, today na since re fanaga di argument tsaro ka go itse wena ha ena date ntwe ha ena lena.
Colonel, you further testified that Perhaps let me put it to you in this way. Now I'm touching on my colleague's client, but it will bear no prejudice. Accused number 2 testified in this court under oath that he received a call. Accused number 3, my apologies. Accused number 3 testified in this very court that he received a call from the police. And the police invited him to Mimosa Mall. I put it to you.
Toki hatate hanyanyana ho client ya colleague ya ka nya ke go le ntwe e tla mme ka mosing ka mogwa o itseng. Accused number 3 yena o itse o fumane call o tswa leponeseng. Are leponesa leo le be le mo memela hore ba kopanele Mimosa Mall. Ke ntse go jetsang yona eo.
Yes.
If I may get clarity, is that what his affidavit says, or is it like my learned friend, he testified here in this court? I can't remember him testifying as such, but there was a statement under oath read on his behalf that states that. If that can be clarified.
Your Worship, testimony, statement under oath, it's all evidence before this court. If my colleague so wishes, I will withdraw the word testify and say he placed it under oath before this honorable court.
Well, we buile tasakano to go we baile tasakano to mona le khotleng lena hore yena o ile a fumana
kopanana le lona Mimosa.
But the information that I have was that the accused person was the one who made a call to the police officer saying that he wanted to have to meet with the police officer that he had faith in, and that he wanted to meet that particular police officer at the Mimosa Mall.
But you agree that what you are testifying and what the accused number 2 placed under oath before this court are in conflict?
Jwale wa dumela nna ke ntwe e buang ka yona ya hore ntwe o testify ona jwale le ebe ena e beile mane ke ntwe tse thulana.
Nna ke na le statement under oath sa le police le no bua le ma bolela ho mokosu ke yena mo letseditse a go batla go kopana le police la le tshepa wa kopana Mimosa.
I also have a statement that was taken under oath by the police officer, where the police officer reports that the accused person was the one who made a call to him and said that he wanted to meet a police officer that he could trust, so they could meet at the Mimosa Mall.
Yeah, Mr. Murori, I thought maybe you will get there soon. I just want to check with you what accused number 3 said to this court through the affidavit. What does that has got to do with application of accused number 1?
Well, Your Worship, certain averments were made that accused number 3 indicated that he fears for his life, and part of the people that he fears for his life from would be part of the co-accused. And what I'm trying to establish here is that clearly, from the get-go, there's a conflict between the first version that we got in this court, who called who. There's a conflict there. And my end goal is to put it to the witness that there will be conflict even going forward.
Yeah, just go straight to the point.
So court pleases.
Yeah, refrain from circumlocating on the aspects that is already before court. Go straight to the point.
As the court pleases.
Thank you.
Sir, I put it to you that accused number 3 has already testified, as I've informed you. And in fact, he did not make that telephone call, nor did he say that he feared for his life.
Colonel, accused number 3 sa beile bopaki ba hae ka pela lekgotla, and ha ona mo a itseng o tshabela bophelo ba hae, and ha ona mo e leng hore ke o itse ke le ponisa ke lona le mo founetseng ntho eo se bile e fapana di tlo wa fela.
I'm not sure whether you are the mouthpiece of accused number 3.
Your Worship, with all due respect, that is a statement that is uncalled for. And with the greatest of respect, I'm not wishing to be anyone's mouthpiece, Your Worship. What I am doing is leading my client's evidence. it is said before this court that accused number 3 feared for his life. He made an affidavit before this very court. He did not mention that. And that is what I'm putting to this witness who says accused number 3 said he feared for his life.
Yes, but my understanding, your client is accused number 1 and accused
Indeed
number
so.
7.
But if accused number 3 fears for his life against my client, but he does not mention it in an affidavit, and the police official who's testifying now says to this very same court that accused number 3 fears for his life, I'm trying to put it to him, and that is what I'm saying, Your Worship. I'm putting it to him that what he's saying is not correct, because the person who speaks for himself has not said that before this court, Your Worship. I do not see where the prejudice is, Your Worship.
Continue, Mr. Moro.
Mr. Court, please. Do you have a comment on that?
Ka mantswe a hae hore o a tshaba ho tshabela bophelo ba hae ebile le mofumadi wa hae ke nahana hore a ka tla testify hobane o la ba ra etsa hore a bue le yena a ba kopana le yena mo e le horeng o na mo hlalosetse ene kopong ya hae o na itse hore o kopa hore a kwallwe police kore disnabeling a kwallwe hole le Bloemfontein hobane o tshaba o tshabela bophelo ba hae ho eda mono Yoshi le di fotong ha o ka sheba ha na lo etsa pointing out o yentse di pointing out a emergency ya hae dimo a ha a batle le hore le di colleagues tsa hae di mo hobane wa tshaba o tshabela bophelo ba hae.
And these are photos that are not before this court.
Can that be interpreted
for
the next question?
Well, Mr. Dipulo did mention that he was fearing for his life. And he even requested to see his wife in order for him to come in order for him to explain that to his wife, that he was fearing for his life. And he even pleaded that he be kept in custody at a place away from Bloemfontein. And to top that all off, even when during the time he was pointing out, all the pointings out that he made, he was having a sweater wrapped around his head, and he was claiming that he didn't want even his colleagues to identify him.
I put it to you that they all shared a cell and no harm. That would be accused number 1 and 7 have shared a holding cell in this very same court, and no harm befell accused number 3, and I'll leave it at that.
So and also be into a bonsang or Kabaliko teaching in by your head get a create a louse Arabi.
Unless you wish to answer.
Ke dumela tsebong ya ka Yoshi mokosua le mo ba kwalletsweng teng ba fapane ka di drone ha ba sebakeng se le seng ke ka mo nna ke tsebang ka.
According to my knowledge, the accused persons are not held in one prison. They are not kept in custody in one place.
Yes, I was referring to the holding cell, and that is what I said here at court.
No, that is the same work at the holding cell. But when somebody holding cell in A1 more and what's not good.
Do you have a comment on that?
That's right. Well, I do not know about that. I am not working in the cells, in the holding cells.
Colonel, where was accused number 1 arrested?
Accused number 1 he was arrested at his abode.
Did he try to resist the arrest or flee from you?
Wile aleka ho hana ho resist o tshwarwa mo kapa aleka ho bali? No, he did not do that.
And did he hand over his passport to you upon your request, or how did it come about that his passport is now in your possession?
Jalo o tlile jwang passport ya hae ebe ho wena? We o fane ka yona ha o e kopa fela kapa ho tlile jwang ebe o na le passport ya hae ho wena?
Ha ke kopa passport ya hae la henda over.
When I requested him to give me his passport, he handed it over to me.
And what else did he hand over to you?
King about the
cell phone ya hae worship.
He also gave me his cell phone.
Abampali ID card ya hae worship.
He also gave me his ID card.
You say he handed over his cell phone. Did he also give you a PIN or a password to the cell phone?
Of the PIN, password, PIN. Well, I'm not certain whether he gave me a PIN or a pattern of a cell phone.
So would you say that he cooperated when you arrested him?
Yes, he gave full cooperation.
Colonel, you testified that from his passport, you glanced that he had 16 stamps in and out of the country, particularly into Lesotho. Is that correct?
But I would say, how about passport you have Fumano Onanza Kela Azwa Lesotho? That's correct.
And you said this amounted to 8 visits.
And in 2 years, we lay able to or Chakete Lesotho 8. That's correct.
I put it to you that you are wrong, Colonel.
So what you say, Colonel? Opposite,
in fact, at a port of entry, one gets 2 stamps to gain entry into a different country and 2 stamps to re-enter the country.
The more who can want the modi gating sale, modi but gating sale. Moto ha akena, ufumana distempe tsepedi. Ho kena ka country nyeo. And le ha a khukela country nyeo a tswang ka ho yona. Ufumana distempe tse ding tsepedi.
Do you have a comment on that, Kevin?
Well, I agree with you on that.
Now, Colonel, you would agree that
let me establish which part are you agreeing that you were wrong, or you agree with the part that 2 stamps when one exits and then when one enter, or do you agree on both parts of the sentence posed to you?
So what you say, Kenneth? When I do man tawaro on opposite, kapa do man tawaya hore motu ha kena fumana stempe tsepedi ha atswa fumana stempe tsepedi. Kapa o dumela tsona di lepedi tse tsa hore o no opposite e dile wa tseba motu o fumana stempe tsepedi ha kena le ha atswa.
Kuri ke ne ke tlhalosa ka ra passport e worship hona le ditempe tse 60 tse bontshang hore wa bona hore ke departure e nngwe ke exit ya tswa ka mana tswa teng jwale ine di ditempe tse 60 mo le ho ke ho bolela ke makgetlo a ka ba robedi mo mokuswana tse.
What I was trying to explain was that in the passport I saw that there were 16 stamps. That in some of the stamps indicated the departure and other stamps indicated the return of the person from Lesotho. So that indicated to me that he made 8 trips.
So I put it to you that yes, there are 16 stamps on that passport, but that a single visit into Lesotho, one accumulates 4 stamps, 2 upon departing from the country, 2 upon re-entry into the country being South Africa, 2 into Lesotho, 2 upon your return.
Shebaka dumela hore ditempe tse hlaelang passport-ong eo di 16 empa ntho e go jwetsang yona ka ditempe tseo ke hore ha motho a kena ka hara Lesotho ho tempuwa habedi a ba kena mohlang a khutlang ha khutla ho tempuwa hape habedi hore a kgutlele hape ka South Africa. That is correct.
And therefore 16 divided by 4 is 4. That means accused number 5 only went 4 times to Lesotho.
Jale ya arola 16 ka 4 ke e o fa 4. Hobane ntwe e tlo bontsha hore o ile ha 4 fela ka Lesotho mthe accused number 1.
I apologize, Your Worship. I referred to the incorrect accused. I'm referring to accused number 1.
Okay. What accused number 1? Haven't o dumela ha kena o fuwa stempe tse pedi ha tswa o fuwa tse pedi. E bolela hore o ile ha 4 hela. O ile ha 4 fela e.
Ho bolela kana ke nna ke ntse phoso ka calculator Worship.
Well, that would mean then I am the one who made a mistake by calculating each stamp as it would be per a trip.
To err is human, Colonel. It's not a problem.
Well, when it's a poso, kinto is one kimang lemang, Colonel. I think
you also testified that the last time that there was movement on this passport, the last time that there's a stamp on it is in November. That would be November 2022. Am I correct?
When I was loud at Ella, how neonale would say it's a passport to ena for Samaya in November 2022. That's correct.
It was your testimony that accused number 1 has relatives in Lesotho. Did you investigate where exactly they are located?
When I was accused number 1 and I learned the family cutting Lesotho come on. We lewa fupuza he for na do you family I did not investigate that.
Put it to you that accused number 1 will come and testify before this court and say that he does not have any relatives that he knows of in Lesotho, but only people that he communicates with on Facebook because they happen to share the same surname.
I just am one out of Buah na hana di family kamo Lesotho kamo. And batuba abatsebang Lesotho kamo ke batho ba ene hore ba kopane Facebookung banza bua le bona Facebookung le teng ka baka la hore bana le fane e tshwanang fela.
Nna le tshedile ne ke le fumane ele ne ke le fumane o shi o itse o na le di relative ka Lesotho.
But the information that I obtained, I was told that he has relatives in Lesotho.
In fact, he will come and account for each one of those trips. And I put it to you that the first trip was when he accompanied his girlfriend to a tombstone in Lesotho.
And then I would go to Mona Aba and Sapaki Ba Horena Trippy Emwilliam Unakana Lesotho Kamoaluenza. Ile ore ya pele trip ana ya ana ile Lesotho ka na nele ha ana felitse girlfriend ya hae ina le tombstone kamo. Well, I don't know about that.
And the remainder of the trips were to accompany boys to the initiation school.
And it's in the trip tsa di ntseng ho kena ka Lesotho ka mo inele ha feleditse bashimane ho ya lebollo. I do not have any information to that effect.
I'm sorry, Colonel. I believe there's one aspect that I did not converse with you. You indicated that accused number 1 had access to the personnel files that had the address to the people who could possibly be the state witnesses in this matter. Is that correct?
Bona gona le ntanyana le ksa e canvasa lwana. O itse wena bopaking ba hao accused number 1 ona ana le access mo di filing tsa batho ba bang bo ka tsalang ebe ke dipaki casing ena. That's correct.
I put it to you that accused number 1 will come and dispute that.
O tlotla yena ba iphisa kaofela ntwe. I do not agree with that.
He will come and testify that those files are kept by Human Resource Department and he does not know any of your would-be witnesses' addresses.
Toko jetse yena a di file tseo di tshwadwa ke batho ba HR kwa. Ene ha tsebe le hore na ke bomang ba tlotlang e ba dipaki casing ena.
Ha ke dumelane le yona Bishop.
I do not agree with that.
You, and we have already canvassed this, confirm that accused number 1 does not have any previous convictions. Is that correct?
When we say another record, okay? That's correct.
And that what you felt was the burning issue, part of it, for you opposing today's bail application, is the fact that the community is enraged. Is that correct?
And when I'm to baka le ka sehlohlolong le wena ka baka la lona o hanang ho ba fa bail batho bana ke hore batho ba setjhabeng ba kgenne ke nnete
le hape hore mokusuwa ha ka fumana bail ho ya ka case ka nyewe e kgahlano le bona le di ka mokgo e etsaetseng ka teng e tlisa tshabo le tshono le ka hare setjhaba se.
And the other thing is that if it can happen that the accused persons are granted bail, given the nature of the charges that they are facing, that is going to bring anxiety. It is going to bring fear in the community.
You also testified that there was a picket, and I accept it would have been on the 11th of May, because when you testified it was the 12th, and you said there were even people picketing outside yesterday.
When I say nobile na le batho ba ipela etsa mona ka ntle ka mona ba ntse ba picket ka di 11th tsa May. That is correct.
How many people were there? Do you know? Can you estimate?
I did not count them.
I'm asking for an estimate. 50, 100, 1,000?
Tikanyetso fela. Ke go botsa ka tikanyetso fela. Ba ne ba ka ba 50, ka ba 100, ka ba 1,000. I believe there were less than 50.
And you believe that 50 people can represent the view of the entire community?
Jwale wena o bodumela hape hore batho ba ka ba 50 fela ba ka emela maikutlo a community kaofela. That is so.
I put it to you that that is highly improbable.
Ha ona kgonahalo e jwalo he ntate hore batho ba 50 nyana fela ba be ba emetse maikutlo a setjhaba ka kakaretso.
Do you have a comment on that?
No, that's why.
Ki dumela jwale ka ne se ke hlaloseditse le khotlo dipuo tsa batho le ka mokhonyewe ena e le media ka teng bona ka ra khotwena utlile di camera tse ka tsa di different TV station ki dumela hore ka mokhoe ke tswena nyewe na etsaetseng ka teng e tshositse batho ene le ka mokhoe le hore e entswe ka teng e tshositse setjhaba. That is why ki kopa ka pelo le khotla ke ne ke ha ba considere mabaka re fanang ka hobane ke tshabo e re tshaba hore ho ka tloha etsala ntho tse mpe bona kwa Zulu-Natal ho la etsala Senegal KC hona nna etsala ana ke madi a maka e tshwantse a tswe before ka utlwisisa.
I believe according to the talks of people and according to the nature of the charges that the accused persons are facing, and according to how those crimes were carried out, that has in itself shocked the nation. And you can take it from now. You can see how many cameras are here. And those cameras are from different media houses. They are from different TV stations. And you can take an example of what occurred in KwaZulu-Natal. And you can take another example of what happened in Senegal. How much blood has to be spilled before we understand what's going on? I would then plead with them to reconsider this.
So you're saying in making its determination, the court must consider that there are cameras here today?
Jwale ka mokgo o e beang ka teng o batla ho nkuwe tshwaelo yena ya hao e nkele hloohong, o batla khotho e nke tshwaelo eo hobane hona le di-camera ka mo
ntle le tello advocate worship ha se taba ya camera, ke taba ya sapola mo ha re monana hore ke hatella mang kapa ke nempa ke maikutlo le tlhahiso e ke ntshang hodima investigation e ke entse.
Without being disrespectful, notwithstanding that there are cameras here, my view is not about that. It is about the life of a person. What's up? Okay. I was only airing out my views, and I am not being repressive to any person's views.
Sir, you also, and perhaps let me deal with this aspect. You will accept that each case that comes before this honorable court must be dealt with on its own set of facts and merits. Is that correct?
I agree with you.
And you'll also accept, I do not know which specific matter you're referencing as far as KwaZulu-Natal or Senegal is concerned, but those matters, as you mentioned them, are not before this court.
And I bet it's very na ke se di feng tse wena o re bolellang ka tsone tsa go KwaZulu-Natal le Senegal. And hape di case tseo ha se tsona tse leng hore re busy ka tsona ka thomona. Yes, I agree with you.
Colonel, you confirmed the accused address, but you also indicated, that is accused number 1, but you also indicated that there's another address, and this is the address that appears on the registration certificate of his car.
So when we say we confirm address ya empa o bo bua hore hona le address e nngwe e leng e hlaelang mo registrationeng ya koloing ya hae. Yes.
Colonel, I put it to you, well, you further testified, and my apologies, Colonel, you further testified that the address, upon your further investigation, you discovered that it was accused number 1's sister's place of residence.
When I say house to if pisa ya pela address eo ya bobedi ne le address eno hore ke has OCWA accused number 1. That is correct.
So in essence, you confirm that accused number 1 has an alternative address.
Jalo ka mantswe a mangwe ntse o netefatsa hore accused number 1 o na le address e nngwe ya ka dula mo alternative.
Utata hore nka e hlalosa hore a ka dula teng hobane ha ke tsebe maikutlo a ausi wa hae.
Well, it would be difficult for me to confirm that he could stay at the said address because I do not know what his sister's views are.
Finally, Colonel, you testified into money that moved from accused number 1's account to accused number 3 and also to accused number 7. I put it to you that accused number 1, at the right forum, explain the reason for those transactions.
So when I would still pay you money about it, when I literally get in and say, it's accounting ya choose number 1, accounting ya choose number 3, accounting ya choose number 7. That was just a general Kenneth. How is it to for money lemon yet or but accused number 1 abu or what or na in a detail that I see.
Do you have a comment, Kenneth?
Well, let's try Romo.
Kisantse ke mama tsinga ka hore jwale ka ne ke pa tšhelete tseo ke tse tswa TK e re TK kwa kisantse ke ditse mantsinga o tla tla ka bopaki ba ha ke hanetsa
I still maintain what I previously testified about, that those monies were coming from TK Nkwana. Well, he can come and testify whatever he testifies, but I stand by what I initially testified about.
Beg the court's indulgence, Your Worship. Perhaps one final aspect that I wish to converse with you before I turn my back on this honorable court with its Steve. You indicated that the accused, well, members of one Bloemfontein Celtics were not really happy and wanted the accused number 1 in particular, now that we're dealing with him, not to be granted bail. Is that correct?
So when Ronaldo we think the supporters are Bloemfontein Celtic in this Thabo hang and this Sabatle or accused number 1 je loka ha re ntse re busy ask about a fumantshwa bail. Kenneth
ho jwalo worship e seng fela accused number 1 bane ba bolela batho ba shebaneng le qoswena ke dumela haebe advocate tuna shebile le TV ka sonda Pule Mabena e le reng ke pro ya Celtics ya di supporter o entse phatlalatsa ho mang le mang jwale ke yona ke tjho ke le balatedi ha ba khotsofala.
Yes, I agree with you, and that did not go just as far as accused number 1 was concerned. Every person in here, all the accused persons who are facing these charges, the community is against their release on bail. And if the advocate was watching TV on Sunday, I believe the advocate will have seen that Pule Mabena, who is the PRO of the Celtic supporters, said it explicitly that the supporters of Celtic members of Celtic Club are not happy and they do not want the accused persons to be released on bail.
Do you know if Bloemfontein Celtic still exists?
It was Bloemfontein Celtic in the appeal. It does not exist anymore.
So we are talking about supporters of a team that doesn't exist.
Because supporters that team is happening in the thing.
Supporters the Celtic the highly siko banziwa support. Even the club at the support desire kima Marumo Gallants. They buy support.
Even though Celtic does not exist anymore, but the Bloemfontein Celtic supporters are still supporting soccer. And there is even a club called Marumo Gallants that the Bloemfontein Celtic supporters are rallying behind.
And I don't want to belabor this point. Perhaps two more questions on it. Do you know what the fan base of Bloemfontein Celtics was? How big was this fan base in its heyday?
When I said Saole Aulun to the fan, that's Celtic, go fan base, yating nile holo hakaika. Yes, I know.
And you testified that Celtics fans were picketing here on the 11th of May.
And we're not on still parking about the fans are Celtic in the picket and one got 11th of May. That is correct.
How big was the fan base?
Who are you finishing? Do you mean when the court was in process? Well, in process. When the court is proceeding?
Through you, Your Worship. Well, I'm asking when you saw them.
Kibotsa kana go wena o no ba bona.
Ki bolela hore ki se ki le ka wa re ki estimate ki tse ki ka tlase ke show 50.
Well, you told me to estimate, and I told you that they could have been less than 50.
And how big was the fan base? The Bloemfontein fan base in general? You can estimate. I don't expect you to be spot on.
Well,
give or take, could they fill a stadium that carries 10,000 people? The Celtics fans themselves.
Okay, but the supporters are finally look like last go ke batla fela we lekanyetsa fela la sa be accurate in a ne ka etsa ne ka tlatsa stadium sa batho ba 10,000. That's correct,
but only 50 showed up.
Imba ba 50 nyana fela ke bona ba fihlile mona ba picket.
Ke dumela ke ba nile le bogodi ba o tla kwana go.
Well, I suppose those were the ones who were able to make their way to the court.
Mr. Court, please, Your Worship. May I turn my back on the court?
Yes, Mr. Muruli.
Your Worship, just one aspect that I'm instructed to converse with the Colonel. Colonel, I'm instructed that when you arrested accused number 1, you found documents in his car, and those documents were for the Department of Labor for UIF claims. Is that correct?
Colonel, ke blelwa mona ke accused number 1 mona hore wena ano motshwara ka kolonya e fumana na le tokomane mo ile tokomane tsa labor ele tse hone ho lo claimwa UIF ka tsona ke nnete
ditokomane tse ke di thotseng ene le tsa registration ya koloi ke yone ne re kopa koloi e registered le mabitso a mang.
The documents that I found there were those of the car registration, it was when we were requesting him to give us the documents in order for us to see in whose name was the car registered.
Were there any other documents?
Unaona tse ding hape ditokomane mo?
Wila mkosiwa kena ilare o tshwere dipampiri tsa UIF ke yona ntho e tshweu.
The accused person told us that he had the UIF documentation with him.
Did you try and satisfy yourself to see if indeed those were UIF documents, or did you accept his word?
When I will ever photograph out the share or can tickets are UIF kapa o nkile fela ntho a bolelang yona a botsa maka yona.
Ke nkile fela ntho ya bolelang yona.
I just took his word for it.
So you cannot dispute that he is busy attending to a UIF claim.
Jalo wena o ka se hane taba hore o ntse le busy a ntse a lokisana le claim ya hae ya UIF. Well, I do not know about that, and I would not comment on it.
As the court pleases, Your Worship. Your Worship, that would then be the cross-examination on behalf of accused number 1. And I see we are a minute before the proposed adjournment time, so I'm right on time, Your Worship.
Yeah, no, thank you. Thank you for that, Mr. Muru.
Yes, the court pleases, Your Worship.
So, if we adjourn, at what time must we resume?
This time, Your Worship, I'll let my learned senior colleagues advise the court.
Okay, let me start this time from the defense. Mr. Makameli.
I thought that we said we would adjourn for about 15 minutes and come back. I thought that was the initial agreement. So if we'd stick to that, that would be much appreciated.
Oh, you say 15 minutes?
Yes.
Meaning we must come back at 2:15?
Yes, that's what we alluded to before.
Mr. Kwenan?
I concur with my learned colleague.
Confirm, Your Worship.
Official, Mr. Manyuzi?
Yes, with me it's different. You know, other people are just taking notes. With me, I am actually working, so I'll request a longer time than that. Maybe 20 minutes or, in fact, I would request for 30 minutes, Your Worship. But I don't know.
So first 30 minutes, okay. Madam, any time is fine with that. Mr. Matuku?
No, I just also wanted to indicate that the court orderly indicates to me it might take them around about 20 minutes to prepare and feed the applicants before court here.
So 30 minutes is appropriate?
I suppose, yes. Thank you.
Okay.
Then that will be 2:30.
2:30, okay. Court adjourns until 2:30. You are still under oath? Thank you.
I'm on my feet, Your Worship. I'm not so sure as to whether the court would let me proceed on behalf of accused number 3, the second applicant, or the court want Mr. Mururi to proceed on behalf of 1 and 7 in this case. I'm not so sure.
Yes, I think it will make sense because evidence in chief, I think it was in such a sequence. I actually intended to allow Mr. Mururi to proceed with his cross-examination even in respect of accused number 7. If you are ready to do so.
Your Worship, if my learned colleague could kindly proceed. There's just certain aspects I do not want to delay the court on. There's just certain aspects that I need to go through quickly. My colleague may proceed with your leave, Your Worship, and I'm indebted to you.
But then it's fine with me.
No, thanks, Your Worship. No.
Okay, before you proceed, Colonel Flyman, you are still under oath, bound by the oath that you earlier took.
Yes.
Thank you.
Thank you. Colonel Flyman, good afternoon.
Good afternoon.
You know that bail proceedings are sui generis of their own kind, and their main concern is for the liberty of an applicant, and this is a right that is enshrined in the Constitution of the Republic of South Africa, right?
What's about it to Tsamaiso Bailey? Yona mokgwa yona ka mokgwa e leng ka teng ke taba ya tokoloho ya batho ba qositsweng, and ke tokelo ya motho a qositsweng e leng hore e a hlahella constitutioneng ya South Africa. Okay? That is correct.
Thank you. And according to the bail proceedings, what the accused said, not knowing the circumstances under which whatever was said to whoever, it's unknown, it's not before the court, it's a matter that has to be determined by the trial court.
And what's about it? Into a Mona Tsamaisonya Hokopu happy. The total wheeling at the Guamotong at the Vakapasa Tebe Kapamotseva Kapasa Motsebe, getting to tell you hore Bulem Batona. But I'm Kela Capital Talania. That is correct.
Right. And I just want to find out from you, in a nutshell, you're saying the reasons why you opposing bail, you advance the following reasons. 1, there's a high-profile matter that was heard, that was even taken to the parliament. The community is saying the police are not doing their work, and the accused, 3 in this case, is scared for his life, especially from the co-accused, and the community is enraged, saying no bail. That's basically the reasons that you are advancing that the accused should not be admitted on bail.
Sheba Kenel, Mabaka hlaisitseng mo tabeng ya hore o hane o fana ka bail o ba kusuwa mona. La pele, we itse case na ke case e high profile e ilebeng ya nkelwa parlamenteng kwana. O bore hape le baka le leng ke taba ya hore batho ba setjhabeng ba bua ka moggo maponesa a sa etseng mosebetsi ka teng. Le le baka o hlaisitseng ke taba ya hore accused number 3 yane o itse na o tshabela bophelo ba hae wa tshaba ene e kare batho ba neng a sebetsa le bona ba mosetse morao, and o bo bua le ka moggo batho ba setjhaba ba kwatileng ka teng ba sa batleng hore ba qosuwa ba fuwe bail. ke amang a mabaka wa hlahisitseng ao a etsang hore wena ebe ha ba tlo fana ka beng
o jwale worship ke akaritse hore ha ba thusiwa ba ka lokolwa ka beng ntho setjhaba se ka tloa sa nyatsa administration ya justice e le hore ba ka qetella ba nketse mafitho molao matsong.
Yes, that included that if the accused persons could be released on bail, the community at large would frown upon the justice system and potentially end up taking law into their own hand.
The community at large, are you referring to Celtics? What are you referring to?
How about Bashaba, Buaka, in Gabagaba to Basilti, Kapabuaka?
Including one of us.
I'm referring to the general community, including the Celtic fans.
What is the Celtics? What is the Celtics all about? What Celtics? Is it the burial society? Is it a what is it? What is the Celtics?
Celtic yo to buaka yona ke eng that. E le hore ke mokgatlo o patamba kapa Celtic ke eng mo gwa yona ante.
Celtic ke sehlopha sa balatedi bana ba latela soccer team ya Free State.
Celtic fans is a group of soccer fanatics who were supporting Bloemfontein Celtic Football Club.
Oh, these are the fans that used to follow a football club. Is that team still there? Where is it playing? Do we know?
Well, kids support Celtic in the club. Celtic club ayo, Celtic kapao tele.
You're not high satellite.
The club itself no longer exists.
All right. Okay, thank you very much, sir. Now, from what you say into the court, you're showing everything within your powers to say the accused should not, their version should not be believed. They are not honest with the court. By giving us like ideas like accused 3, he has a car that's registered on his name. It's something that did not disclose to the court. There's an old house number that you're not so sure of that he also did not disclose to the court. That is, in a way, he's a dishonest person.
Wala to bua ka yona ke hore ntho eno hore ke le baka le tsang ho hane ha hole ha ho bua ka accused 3 ore ke motho se tshepahaleng ene bopaki ba o hlaisitse mona bo ska ba tshepuwa ba ska ba kgolwa le hore hona le address e nngwe eo a sa hlaisang hore ntse le address ya hae ene le hore le koloi le yona e teng kae sa register wa mo mabitsong a hae ke one mabaka a o buang ka ona
ke mabaka ene e ke buang ka ona o se le anane ke bua ka setjhaba ka kakaretso le the interest of justice.
Well, those were some reasons that I was advancing as to my proposal, and those reasons did not end there. I also included the concern about the Celtic fans as to what their attitude is.
All right. Now let's hasten and move over to this issue of the way in which accused 3 was arrested. According to you, you say accused 3 called a police officer. He wanted a police officer that he could trust.
Are kanko accused number 3 atshoreng ka teng. Wena o itse ho ya ka wena. Accused number 3 o founetse leponisa. Leponiseng le a batla ho kopana le leponisa la ka letshepang.
Ho jwalo.
That's correct.
And he called, according to you, this police officer, what was this police officer's role in this case that accused 3 is involved?
Bona o founetse le ponisa leo. A go re bolelle. Karolo e bapetsweng kapa e bapalwang ke le ponisa lena ke senior shebane le yona. Ke
part wa investigate team ya investigation.
That police official is a member of the investigating team.
Is it a white person? Is it Indian? Is it a black person?
Relevancy for that?
India?
No, Your Worship, I'm just trying to figure out the rationale behind the call and the conversation that they had. There's certainly there should have been a conversation between the accused and the particular police officer who was there, and I don't see any prejudice by trying to figure out who is the race of this particular police officer. I see absolutely no prejudice in it.
Okay.
Thank you.
I understand.
Is it a black person? Is it white? Is it Indian?
The police official was a black person.
All right. Now, you know what I found so difficult to understand in this whole matter is, if you would just apply your mind to this whole process, where would accused 3 get the numbers of this particular police officer that he called?
I want to say inclusive mona how e sheba lo ena ka mkhoka e sheba nka teng. Accused 3 una ka difumana ka di nomoro tsa le polisa lona lena la ile nga difone. I have no idea.
Yeah. You see the reason why you don't know? It's because things did not happen in that way. I put it to you, they never happened in that way.
The way it's your Yoshi, the statement is sale police, Sinelisiet, Osinotiguan, Mukusuaki and
But that is just as far as I know. Even the statement that the police officer made is written the same way as I'm testifying right now.
You further agreed that it's human to err, right?
But you may already pause the Malamuhatisi, Hargai Gasut, Kappa, Homotu, Fela, or Kai, it's a pause. But I do not understand.
When my learned colleague asked you certain questions, you admitted to have made a mistake somewhere, and I'm saying it's human to err. It's every person can make a mistake.
More than now, I need to put it out where now what you are more in the process. So they can take you for a Mutuyemo Lemo or the Eta depose. That is correct.
And you say he said to this police officer, he's scared for his life.
When I was with the police,
against the colleagues that he's working with, the co-accused, to clarify the position.
And has a rate like this when I would say on the Atabella Bopilo Bahai, or one of Bakusua Mole, now Bagana of the Akoti. That's correct.
And you know that the accused was arrested on the 13th of April 2023.
Yes.
And since that day, he has been, in all appearances that he has been coming to court, he has been locked up in the same cell with the accused before this court, and we have never had any complaint emanating from that.
And I shall not work at Satilio and Alona, I sale, ante anale baqhuswa mo le bona le kwa antsa hlaela le khotleng
In fact,
ka matsatsi a hlaela le khotleng ka ona ebile kae kae ona tsamaya a kwallwa le bona baqhuswa mo le bona ene ha so ka ho ba le tletlebo e tshwanang le eo e hlaelletseng.
in fact, he was arrested 2 days earlier, according to the charge sheet, the 11th of April.
Beg my pardon, Worship. Thanks. On the 11th of April, 2023. Sorry about the date. And he has been locked up here at the cells, holding cells, with the co-accused, appearing with him in this court, and we have never had any complaint whatsoever emanating from any of them.
And hanzo hlala khotho mo ene ho palweng le bona mo jwalo ha se ba go utlwa gona le complaint fe ka pa fe e hlaelletseng ka baka la hore ba be mo se bakeng se le seng. Well, I do not know.
Thank you. Kenna, the reason why I'm putting that question to you is because there is no such a thing of fear of co-accused persons. And I think you'd agree with me that it's not like I deduce from your evidence that it's not like he's scared or fearing for the people that he doesn't even know to be, whether they are accused persons, whether they'll be arrested at any stage or not. I mean, I'm talking about people who are actually working at the institution.
Accused number 3 owner or Savannah the co-accused it's a high and happy how na le lebaka la hore a tshabe motho mo kapa o feng la o sebetsa lena kapa ke motho a tlo tshwarwang le motho la a tswang group 4 le yena a tlo tshwarwang ha tsebe lo ke bo mang bao so ha ona lebaka le ka etsang a be le tshaba ka bophelo ba hae kgahlano le batho sa ba tsebeng.
Yoshi mokusuwa ke yena ana bolela hore wa tshaba for bophelo ba hae jwale ka se ke hlakisitse le hore le nako ana lo etsa pointing out to group 4 ona ipatile sefahlego a tshaba re ha abate ba be ba mmona.
Worship, like I have said, the accused person was the one who reported that he was fearing for his life. And even during the time he went to do the pointing out at the group 4 prison, he was covering his face, claiming that he didn't want his co-accused to identify him.
The accused during the trial, because we don't even know the circumstances under what you say was said, if it has ever been said, but then he will deny at the trial that he ever said something like that. He will tell the court exactly what happened, that in actual fact what happened is that he was home on that particular day, called by a police officer, and they told him that he must come to Mimosa Mall, and that's where he went and he was arrested.
Ke hore le ha bene di buile ditho tse o tlotla mona a di tatola ntho tse a itatola tsona hore yena ha a soka a bua dintho tse a founa a batlana le police ntho e etsaetseng ke hore o na le hae a ba fumana call ho tswa le police le mo jwetsa hore le batla go kopana le yena Mimosa Mall.
Yoshi kwa magatsa ha mokusuwa a re yena o bitseditswe Mimosa Mall le ponesa lena le sebetsi Mimosa Mall ke dumela a ka ba bitseditse police station.
It's surprising when the accused person claims that this police officer called him to Mimosa Mall when the police officer is not employed at the Mimosa Mall. The police officer would have instead called him to the police station.
No, but Kenan, no one has ever said that the police is employed at Mimosa Mall, unless you want to tell us something that we're not aware of. No one has ever said that.
May I object to that? That is his response to the issue that the police are the ones who called him, invite him to Mimosa Mall. And his response is precisely that. No, the police officer is not employed at Mimosa Mall. He would have called him at the most at the police station. Now he's being taken up in terms of no one said so. That is his response to the question. And there's nothing wrong with that.
Your Worship, no one has ever said that there's something wrong in that, with due respect. And we don't know what was in this police officer's mind at that particular time. But then, what I've got a problem with is the narration that says that he's employed at the mall. No one, I mean, it's given. No one's employed at the mall. No police officer is employed by the mall.
Yes, Mr. Makamedi.
Thank you, Ocean.
You may proceed then.
Thank you. Yes, you see, even the time he was called to the mall, he was not even arrested at the time.
While Kalena Boyo are abilating Molong Mo, Onaspe Afharwa Kanaboyi.
And you further said in your evidence that it will take you a month to 2 to have these investigations in this matter finalized.
And a Pakiba is a long affaidi with a wedding pedi or the Kukutosa case in a Dipeta. That's correct.
You say more people are still to be arrested.
Or Unzula to Baba and Happy Bansim Batwa case in That is correct.
And you know that you cannot use or you cannot arrest a person as an anticipatory to a form of punishment. Okay? You cannot just ask the people to be locked up with a punishment in mind. That's not the purpose of bail application.
And what's about us? I said, Tawarabatuarala Hore, Ibese Ile Hawa Panishu. Ibile Lintail has a space Kopea bail.
Mr. Magami, do you intended to say arrest?
Your Worship, the purpose of bail application, that's what I'm saying. You can't keep the people in custody for purposes or to continue with your investigation with the purpose of anticipating a form of punishment. That's basically my question.
Okay, what's okay? Ogase beba to clamo. Elore wena osona le tebello ya hore batho bao ba tlo punishiwa bao. Ha se sepheo sa kopo ya bail se o ka se be batho fela ona le tebello ya hore qetellong batho ba tlo punishiwa. That is correct.
And you know for a fact that a person that has been arrested, the person remains innocent up until proven otherwise by a competent court.
And whatever hore motho a tshwerweng o nkuwa a sena molato go fihlela lekgotla la dinyewe le le hore nna le boiphihlelo nna le boitsanape bo e ba lona le le reng molato. That is correct.
Thank you. And you said in your evidence in chief that accused 3 is dismissed. Edwin.
And we say accused number 3 or le komisabiti. That is so.
Do you perhaps know when was the disciplinary hearing?
You know,
accused 3?
Disciplinary hearing ya accused 3. In a journey. I do not have the dates of the disciplinary hearing.
And you know that the accused is not employed by G4S is not even employed by the DCS.
What's about it has accessibility G4S, happy accessibility DCS. That's correct.
If you contacted Integritan Security to find out his position.
When I will kill our phone, contact about Integritan Security. About a position here, yes, I did.
But let me correct you here, Captain Kenna. The accused is not dismissed that way. On the day of his arrest, the 11th of April 2023, he was actually off.
Accused number 3 halelekiwa msebetsi. Ka 11th tsa April ka 2023 motho eno o na le off.
Na sekisifumani worship hoto ulelekwe.
But what I obtained from my investigation was that he was dismissed.
Yeah, you see, this is quite disturbing in the sense that a person is off on the 11th, and then he then gets a call, he approaches the police, he gets arrested, and all of a sudden there was a disciplinary hearing and this person is dismissed in his absence.
I want to hear this step. That's really. The about Mutukiana offer, Ufumana call on policing, Yena Oya, the police send them for anything. Personally disciplinary hearing, Kabakalauri, Yena Aikiste, more enough for to think the police. Ebe, also to Waleluku of 70.
Na sekisiti ba worship. Or give it to Kibonobar, Uleleki, Musibiti.
But what I know is that I was informed by them that he was laid off from his work.
Yeah, but the person might have given you wrong information because according to him, he's still employed there.
Well, information is wrong. Obano ya kaye na unza sebetsa integrity area.
Bona bare ba mulelekile worship.
But his employers say they have dismissed him.
Right, let's proceed. And when my learned colleague asked you about the blankets, you said there are blankets in prison. Do you even know where this accused it's locked up?
Shebaha mujismona na about ana botsa hona diko diteng mo ka diko dilekane wala o itse no diko diteng mo motho a kwaletseng teng wa tswa motho o kwaletswe ka
ho jwalo yoshi.
Yes, I know.
But have you been there to see the people locked in there as to whether they have sufficient number of blankets? Or do you even know how many blankets is he using at his own house to sleep at night during winter?
Ibo kile wa ya mo walo sheba batho ba kwaletsweng ka mo hore na bana dikobo tse anetseng and lore na di uka dikobo tse kapa wa tseba hore na yena o sebisa dikobo tse kae ha.
Yeah, but as for other people, would it be necessary for him to go and check how many blankets are they sleeping with? Can you just limit to your question to accused number 3?
It's fine, Yoshi, but I do not see any wrong in the type of question that I've asked.
Yeah, but
in the sense that, if the court can just allow me to explain.
Yes.
In the sense that this is a bail application. Hearsay it's admissible in bail application, and we have been hearing that even the members of the community are saying it's on behalf of other people. That has been allowed throughout.
I don't have a problem with that, but to generalize, to say other people, you must limit your question to accused number 3.
Thank you, Oship. Thank you, Oship.
Thank you.
Have you been to the prison to see how many blankets were or are available for accused 3 in the place where he's locked up?
Ukila wa tronko moe. Olo sheba rena diko ofue kapa allocated ko botse kae gore re robala ka tsona mo a kwalletsweng teng?
Ha ke so, Your Worship.
I've never been there.
So his version would stand to say that he's given less number of blankets, and as a result, he's getting cold.
Jole ntho a buang e tlo stand up. E tlo ema mona lekgotleng la hore ntho ya hore yena dikobo tsa difuwang kwana kwa kwalletsweng teng ke dikobo tse mmalwa tse nyane and wa hatsela ha di mo anele.
Ke dumela Your Worship hore ha hatsela a ka kopa ho fuwa dikobo tse ke dumela le tronk e kebe ya hana ho mo fa dikobo jolo ka hanentse a kopile le nako yane ha le otindale hore o kopa hore a iswe Sasolburg prison.
But I believe that if he was getting cold in any way, he could always go to the prison officers and tell them to give him more blankets. And I don't think any officer would refuse to give him more blankets.
Yeah.
And he even made a request when he was locked up in ordinance arrest that he should be taken to a different prison. And that was hidden.
Unfortunately, sir, that's not the position. He was never given extra blankets, and as a result, he contracted flu. And when he went to the health facility in there, all that they could dispense was a Panadol.
Seba tshweo e buang ha e a se ka mkho ha e ka mkho wena we bolelang ka teng o hanetswe ena ka dikobotseng ka mkho wena o buang hore ka se hanele a se ka mkho e etsetseng ka teng ibile ka baka la o ile a ba a tshwaetswa ke flu mo ya ba ha a ya ko facility tsa health tsa mo prison mo ke a fuwa Panadol fela
Ho thata ro nka tshwaela.
Well, it's difficult for me to give a comment on that.
Thank you. So the accused doesn't have a passport, right?
Hana passport to accused, okay? Correct?
And there is no ties of him out of the Republic of South Africa that are known to you.
And I want makama ahai kantle ho Republic e wena o watseba.
Che hai ha ke tsebe.
Yes.
And on those basis, you cannot say that he's a flight risk. He's unlikely to stand his trial if released on bail.
And ho ya ka ntshina e re bua. Ha ona ka mgo wena o ka mo beang le fapeng la batho ba ile hore ba ka baleya nyo ya bona ile hore ke motho a ka skitlang a tla case nya hae a re eme.
A ke tsebe moshi.
Well, I don't know.
Right, and yes, we admit that the accused are facing serious charges, right?
We ametse tabare ba kusua ba tobane le diposo tse ding tse mpe ka ho fetisisa ke. Correct.
But that's not the only determining factor to determine whether they are eligible for bail or not.
Ipantso a sona fela e nkelwang hlong ha o tlo utlwa tsetso hore na batho ba e fumana bail kapa ba e fumana.
I get to you, she.
I do not know.
On the issue of the community saying no to bail, I want to say to you, the accused, this incident took place more than a year ago, right?
Mataba ya hore batho ba saba ba re batho ba ska fumana bail ke batla hore wena ketsano ena e etsaetse nakong e fetang sele e fetileng, okay?
Correct? And the accused was a member or part of the very same community that you're referring to, and he is rooted in Bloemfontein, which is something that is not disputed. He stays in Bloemfontein in a particular house. You mentioned the address that you confirmed.
And I accused in a sale alikara in a community in a Obankayo. Okanako coffee. And I came to Elo Hore, what's a Pami Mona community, United Bloemfontein, Eunzum Wakayo and Donajon. Or I lent to more to land game on a Mona Bloemfontein.
Can I go to Sichavani Sazivuri? Mugusua Winzi.
At that time, the community had no idea what the accused person had done.
But are you saying that the very same community that you're referring to, I didn't know that there was an escape at G4S, wherein an inmate was aided by people working in there?
What I'm telling you, Chabasel is such a horror who will escape G4S. Mono hore mo tshwaruwa o thusitswe ke batho ba sebetsang mo.
Sena ke dumela ha ke sa fotse yoshi se hlahelletse ka bo matchi e ba public domain ya hore ho etsaetse eng ka hara G4S.
If I'm not mistaken, it all surfaced around March, and it came to the public attention what actually happened at the facility.
The question is, are you saying the community was not aware that a person has been aided to escape prison over a period of 12 months?
Potso ke hore na ore batho ba setjhaba ba ne ba sa tsebe na hore hona le motshwaruwa a thobileng tjhankaneng a thuswa ke batho ba sebetsang mo selemong kaofela di kgweding tse 12 kaofela.
Jolo ke se ke tsholo hore ke dumela bongata itse ba itse ka March hane o posta photo ya Thabo Bester hore ke yena ba mmone a le ulwe kana go tseno setjhaba ne le silile fifi ba sa tsebe hantle ho etsana.
Just as I've said, it only surfaced in March, and it became in the community's attention only in March that there was such a thing that had happened there. When Thabo Bester was posted in social media, claimed that he had escaped from the prison.
Kenneth, I put it to you that this matter was known by the community that you're actually referring to, that this is what has taken place in March, is it March? In May last year. Already it was known.
Can I tell you something? It's a bahala hore. Kinto it's in May kwana last year.
The accused at that time was rooted in Bloemfontein, and nothing has ever happened to him. And I put it to you that should this court exercise its judicial discretion to grant the accused bail, nothing will happen to him.
And I can't go fail. Accused 3, I said an answer to late, Alemona Bloemfontein, Elohore, Nale, we like Bloemfontein, was not little later along way. And in Twig Batam, just an accurate Lepotalina, Haleka, it's a Kitayana, say Mulau, yeah, la local law. Accused. I want to say alarm.
Yeah, that was a long question. Let us break it. The attorney says the community knew a long time ago, from May 2022, about what happened. What is your response?
Well, Robe, the court. Yapil Kiore, Mweli or Card May 2022, community in a country, or when? That is not so.
Then, accused number 3 rooted out in the same community of Bloemfontein, and nothing happened since then about him.
Karolo e nngwe ya potso e reng ha e sale a le ka May 2023 ntho e etsahetse a tsa le community yona yena a tlameleng a lokollelwe ho yona ha ona letho le etsahetseng ho yena.
Ke dumela worship hore ha jwalo ka se ke tjho setjhaba se ne se sa tsebe ka hore ba o entseng party ya bapetse hodima escape one ntho ene tsebala worship kana go tseo ho no tsejwa fela ho Thabo Bester o committee suicide ka hara president for
worship. I believe that the community at that time had no idea what role accused number 3 might have played in the whole situation. And what I know about what the community knew then was that Thabo Bester had committed suicide inside the prison facility.
And should court grant accused number 3 bail, nothing will happen to him, as nothing happened to him before.
Well, ingwe karolo ene le yona e hore le ha le khotla le ka mo fa bail ha ona letho le tlo etsahalang ho yena hobane ho nontse ho sena letho le etsaetseng le pele a tlo tshwa.
Ke dumela worship hore ha o tla le setjhaba se ka motswela matla ho ya ka ketsahalo le hona jwa le hore ntho etse case ena e tsebala jwang go ba etsaetseng le yena moqosuwa se a se kopileng hore are ke tshabela bophelo ba ka hobane ena o fane ka tshedimosetso ho tloa party ya e bapetseng le bomang ho fihlella le ka hore ditopo di kene jwang le teng ke ntho ya hlalositseng admission statement ya hae.
Thank you, Master Makamedi.
Your worship, I think if the accused person can be released on bail, the community is definitely going to be after him, and the accused person has told us what he knows about what happened, and even he, according to his request, he has said that he is fearing for his life, and he told us about the information. He told the police officer about the information that he played, and he even told every person into detail. He told the details about what each and every person played and how the corpse even landed at the prison facility.
As I said earlier on, we don't know the circumstances under which that was done, and that is a matter for a trial court.
Jalo ka setse ke buile ha re tseba bona motho ha beneng o di buile ditho tse ona di bua ka tlasa mabaka a feng, and ntho eo ke ntho e le hore tlo sekasekiwa ke lekgotla tshekelo lekgotla le sekang case ka bona. Well, that's so.
Thank you. Would you agree with me that because there's never been any disciplinary hearing against the accused, is not aware of who could be the witnesses in this case?
O dumelana le nna ha ke re ka ba ka la ha o so ka ho ba le disciplinary hearing khatlana le ena ha ka se khone o tseba ile ke bo mang ba go batho ba ntipaki.
Or let me put my question in this way. Because there's been no hearing, the people that would have testified in that hearing are unknown to the accused, the accused three.
Harebe ka mkhotsi ena ka ba ka la hore ha ka ha ba le hearing khatlana le ena le batho ba neng ba ka paka hearing ya hae ha tse ke bo mang tsatsing. Well, I do not know whether there was a hearing or not.
There was none. I'm telling you, there was none.
ka o jwetsa o no sena hearing kgatlhanong le motho a o soka wa le hearing kgatlhanong le
right? You know, in bail applications, the court can attach conditions on the bail, and if the accused, for whatever reason, fails to comply with the conditions attached, then the person can be rearrested.
wa tseba masehemo di tabeng tsa bo dikopong tsa bail le khotla le kana la fana ka di bail tse leng hore motho a tswileng ka bail ha sa ikamahanye le tsona dipeelo tseo a ka tshwarwa hape a kgutlisetswe ka hare
bakeng sena na for accused ne ke kopa le khotla hore le ske la mofa bail jwalo ka secure.
But in this instance, I would plead with the court not to grant the accused person bail.
No,
as I've already said before.
Yeah, no, I hear what you're saying. I hear your request to the court, which the court will deal with it at a later stage. But what I want to figure out from you is that you do know that bail can be, conditions can be attached to the bail.
Yeah, can you control when I go open the ntse ba tla go botsa na ke taba hore na wa tseba hore hona le dipelo tse ka beuwang le bail ha motho a lokolotso botse ha o lokolla o itse china ha o le kantle ka mo
ke a tseba yoshi.
Yes, I know.
Thank you. And the other thing that I wanted to ask you is, you know that a picket outside this court does not influence the court's decision when coming to bail application. The court has to exercise its discretion. It's not an issue on its own.
What's my le picket is a lankante home ya le khotla ha ina tshusumetso e feng kapa e feng qetong e tlang kwang ke le khotla ntse le khotla ntse le tlamehile lona le tlonka diqeto tsa lona ho latela ka mogodi taba di hlahiletseng ho lona ka teng.
Ho jwalo yoshi.
That's correct.
Yoshi, may I just approach?
Yes.
Thank you, Worship. Just last aspect that I didn't take up with you, it's the address that you mentioned in your examination in chief, that you said is appearing on the accused's e-notice documents. For his old battered car, if I may put it in that way. Remember?
So I want to say about Kayona in hore ilele mabapili address ono bua Kayona mo in hore ile more information ya Tuesday in ke le kekolo ya gale le sentse sa tle le sebetsa sa o pola lo bule ka ona ka mo na le address e mo ka teng.
Ha ke sa fosi worship ki le ka re ki bank statement ding ya ha.
If I am not mistaken, I said that it was the address that appeared from his bank, from his Capitec bank statement.
Oh, okay. And you say the address is 15750 Joseph Letsoalo Street, Bloemfontein.
15750. Yeah, we say address ke 15750 go Joseph Letsoalo. Onamana Bloemfontein. That's correct.
And yes, indeed, you said it's the bank account. Correct. If you conducted investigations to check who stays at that address, or is it an address that can be found or not found?
e le gore o etse diphuputso mo gore na ke address ya manye kapa ke address e kgonang go fumaneha kapa ke address e sa kgoneng go fumaneha
ha ke etsa diphuputso Your Worship.
I did not conduct any investigations pertaining to that address.
Okay. So you won't dispute if I say the address belongs to the father of the accused?
So anna go bolela hore ke address ya ntate wa mothusiwa o ka se kgone ho hanana le. I do not know.
Thank you, Worship. That's my cross-examination on this witness. Thanks.
Thank you very much. Mr. Kwenani.
As it pleases the court, Your Worship, another colleague has just indicated, brought it to my attention that it is 3:30, but I'm ready to proceed if the court is so inclined that I should proceed.
Yeah, I would not prefer to deal with the cross-examination on the witness on a piecemeal. We should rather roll the matter over if it's possible.
I'm in the hands of the court, Your Worship.
Yes, I think this is an appropriate time for this matter to be adjourned.
Is the court thinking of tomorrow?
No, I said it may be rolled over. I'm not necessarily saying tomorrow. It depends on the availability of all the legal representative and the public prosecutor.
And on Thursday, I'm chairing interviews, which unfortunately cannot be postponed as candidates already have been invited and are on their way. I'm unfortunately not available. I'm, however, available on Friday.
Mr. Mururi, is your schedule?
Your Worship, I'll fall in line with Friday. So, God, please.
Mr. Makamedi.
Your Worship, it's very unfortunate that I'm not available on Friday. I'm also not available even tomorrow. I also have interviews to conduct tomorrow. So it's just unfortunate. The only time that I can be avail myself is on a Thursday, but
okay. Mr. Kwenani?
I don't know. I'll try to be in line with whatever is proposed pertaining to the dates. The sooner the better.
Thank you. Mr. Gary Potter?
Worship, the first available date I will avail myself, Your Worship.
Okay.
I was thinking of Friday, but unfortunately my colleague is not available.
Yes, we can check next week. It is clear that it's not practically possible for this week.
Monday, Your Worship?
22nd.
I was proposing Monday and Tuesday, but it appears Mr. Maruri is not available on both days.
Your Worship, let me just confirm that indeed I'm not available on Monday and Tuesday. Perhaps, Your Worship, if I may be, yes, if perhaps we could take a short adjournment. I believe these great legal minds will come to a date, Your Worship.
I hope you are not insinuating that this one is a very little man.
That is a fountain of wisdom, Your Worship. I would never insinuate that.
Thank you.
As the court Jesus.
All right. Court adjourns.
All right.
I recall 20, capital A, stroke 113, stroke 2023, Sinohe Ishmael Maswara and the others. Bishop, thank you for the indulgence, and we managed to come to a sort of a compromise. It would appear that Friday, the 19th of May 2023 is suitable to all of us. Mr. Magamedi maybe will address the court in terms of what the situation with him is as a priest.
Mr. Magamedi.
Thank you, Your Worship. I indicated to the court that I'm not available on Friday, but seeing that we done, I'm skeptical to say done, but seeing that we're done with the cross-examination, I'll ask my learned colleague, Cecil van Wyk, to stay in for me, and the matter can then proceed. If there's any other thing that may crop up that would need my attention, he'll give me a call and we'll see how do we proceed with that. Thank you.
In order, Mr. van Wyk, can you confirm this?
Your Worship, I confirm. As it pleases.
Thank you. Mr. Kwenane?
The date that has been proposed is suitable for us, Your Worship, and we would be ready to proceed. As it pleases the court, Your Worship.
Mr. Buota?
As it pleases the court, Your Worship, I confirm the date and I confirm we'll be ready to proceed.
Thank you. You may rise up then.
May I also humbly request all court officials that perhaps we try our best to start at 9 on Friday. I don't know. I know the court has other matters already planned, but we can make some arrangements. If we can start at 9 on Friday, as a president.
Okay, Susan. On Friday we will be starting at 9 o'clock. You will be ready. Thank you. Right. Case is remanded until the 19th day of May 2023. Same court number 20A. For further evidence on bail application. The accused will remain in custody until then. Thank you.
As the court pleases, Your Worship.
Oh, hey, Colonel Flyman, I always forget to turn my head to you. You are also warned for 8:30 and to remain in attendance until you are duly excused by the court. Failure to adhere to this order, warrant of arrest will be issued. Thank you.
And he will execute it himself. We may know, I suppose there are no other matters.
Yes.
We can then adjourn for the day. Thank you.
Court adjourns.